Please, Your Lordships.
Yes.
Lordships, I beg to mention hearing item number 11, 12, 13, Your Lordship. Lordship, here the parties.
Why you? Nobody wants to do that matter. Every time I come, there is always somebody saying, either Mr. Siti Jamil will be saying, or Mr. Jimomi will be saying that some sort of some compromise negotiation is going on.
Yes,
Now, what is it?
Yes, some compromise is going on. So we have asked our clients. So we have asked our clients to give us in written, Your Lordship.
We do one thing.
Yes, Your Lordship.
We direct these matters not to be listed till a request is made by either of the councils for listing it, that there is no chance of any compromise. Makes no sense. Every time the matter comes up, nothing has happened.
We have asked them to give us in written, Your Lordship.
What
So,
do we
Your
wait?
Lordship,
Once you have it, you come to a final thing that there is no compromise. Make a mention. Not to be listed. Better off. Simple. Every time it comes up, spoils out our ink. I know this. Because not to be listed. The other parties looks the list or listing it. Then you can hear.
I don't know.
Okay, I think better of it. Heard Miss So-and-so, the learned counsel, appearing on behalf of the petitioner, appellants in the 3 writ appeals. Mr. So-and-so who appears on behalf of the private respondents.
Yes, Lord.
Anybody from the government?
No.
This court have taken note of the records. And every time the matter has been adjourned, every time requests have been made for adjournment on the ground, there's some talks of compromise. Taking into account the above, it is the opinion of this court that we are of the opinion that the matters be not listed, should be adjourned sine die till appropriate application is filed before the registry by either of the councils, by either of the councils for the parties, that there is no chance of any compromise, or some compromise have been arrived at for closure of the present proceedings. So accordingly, the writ petitions, the writ appeal stands adjourned sine die. Liberty given to the councils for the parties to file an application before the registry. In the circumstance, there is no scope of any compromise, or a compromise have been reached.
Much obliged. May I please, Lordship?
Yes.
My Lord, I pick commission item number 7. I am respondent number 4.
CDSA has no business.
I have not yet received any instruction, my Lord.
Yeah, no problem with that.
in this case, I had filed the affidavit this morning. And also, Your Lordship,
I just received this affidavit just now only.
So you want to file a reply?
Lordship, the council is appearing through VC, my lord.
Huh?
The leading council is appearing.
May I please, Your Lordship? Lordship, actually, CGSC is not so important party here, my lord. The issuing authority is respondent number 2, that is Home Department, my lord.
and Your Lordship, here the
Home
advice.
Department has filed the affidavit.
Yes, my lord.
So therefore, would you like to file a reply?
My lord, matter may be hard, my lord. Today, I have gone through the records, my lord, and I have gone through the affidavit as well, my lord. There is nothing to reply, my lord, in the affidavit, because everything is clear and everything is in the record, my lord. Prima facie, it's made out a case, my lord, because the very basis of the PIT and DPS is, my lord, violated, and the other things, my lord, which will be in later stage, my lord, I will love to, my lord, make submission on those points, my lord, because prima facie this case is made out, because the very factual, my lord, there are some facts which are not even prima facie made out, my lord. This case is not should not have been registered under PIT and DPS, my lord, because the relying case is also, my lord, something, my lord, shaky, that foundational fracture shaky, my lord.
We'll have it next week then. When you see the CGSC's role is to the effect that they have an authority
My
to
lord,
nullify a detention order.
my lord.
Now, if he has not received the instructions, but without going into that, if we can look into it merely on the basis of the detention out there, whether the detention could have been made within the purview of the law, then obviously we can do it. We'll have it next week then.
Your Lordship, yes, Your Lordship.
You
And even
produce
the
the
advisory
records.
board is yet to give its report, Your Lordship.
Huh?
Even the advisory board is yet to give its report, Your Lordship. So
My lord,
it's in a way, Your
One
Lordship.
thing, we have it next week.
Okay, Your Lordship.
You produce the records. Because without the records, we are not in a position to decide this. And Mr. Counsel, or merely on the basis of a prima facie opinion, we can pass an interim order, not quash up. So therefore, let them produce the records. And in the
So, my lord,
meantime,
may I-
if you want to file a reply, you can very well file a reply by Monday.
my lord, may I pray one thing, my lord? That, my lord, may I pray for interim, my lord? Till then, my lord, because on the last occasion also, my lord, it was observed in the order, my lord. Will see in the last order, my lord, last line, my lord, of the order of the last date, my lord. My contention is that, my lord, if I get the interim, my lord, because prima facie this case is not made out. If your lordship comes to only 2-3 points, my lord will be clear that this is not even a case, my lord, under PIT and DPS. So my only contention is that, my lord, if your lordship allow me to remain on, my lord, interim, then, my lord, they can file as and when they require. And then one more thing, my lord, regarding advisory board's opinion, my lord, we submitted one representation, my lord, that is not even yet considered, my lord. So
If this
everything is, my lord.
detention,
Yes, Your Lordship, is in detention.
how can there be an interim order passed, Mr. Counsel? Wouldn't that interim order amount to a final order?
My lord, that is my only submission only. My lord can fix this matter on next week, my lord. Date may be fixed, my lord.
Anyways, we'll have it next week. Let us produce the reports. Item number?
Seven.
Seven. Ms. So-and-so, the learned counsel who represents the state, submits that an affidavit in opposition has been filed. Mr. So-and-so, the learned CGSC, submits that he is yet to receive the instructions. Taking into account that these matter, the present proceedings is the proceedings for a writ in the nature of habeas corpus for quashing the detention proceedings for the petitioner. We have the opinion that the matter requires an urgent disposal. Accordingly, list this matter again on 3rd of June 2026. In the meantime, on the next day, Ms. So-and-so, the learned counsel appearing on behalf of the state shall produce the records.
Mr. Lordship. Obliged.
Right, my lord, and I beg to mention item number 8.
Same prayer.
The same prayer, my lord, this one, I have received a scanned copy of the petition opposition, but the original copy I have not yet received, my lord. So that I have approached the registry to file that.
Mr. Lee, you will only say out there that you have applied your mind and rejected the representation. That's all. Isn't it? No problem. Yes, Mr. Sophie.
Yes, my lord, if it can be taken up today.
Why?
Yes, already.
Who is the appearing for the government?
Yes, Your Lordship.
You got your records?
Yes, Your Lordship. That will, of course.
Hello, you take it up today.
Yes, my lord. My lord, I have a scanned copy of that petition
Okay,
opposition.
we'll look into the scan code.
I tried to file the registry, but registry refused to accept it, so.
We'll have it. Okay, next Monday. In the meantime, but it is a case of preventive detention. If we do, what is the case, Mr. Sophie?
My lord, the detainee has been detained under NSA. And here my main contention is that the detaining authority has not disposed of my representation.
But
It has
The-
been disposed to your lordship. Reports will reveal that it has been
The
disposed.
detaining
within time.
authority
you
has
have
not.
the records.
The state government has, my lord.
Okay, we'll see when the matter reaches.
Fine, my lord.
We'll see where the matter reaches. Not
Obliged, my lord.
mention that.
Please, Lordships, I beg to mention item 14. Hearing item 14.
1-4. Oh, you
Yes,
have asked
Lordship.
for an adjournment.
Lordship, the arguing counsel for respondent 5 has some personal difficulties, so I pray the matter be listed after 2 weeks, Lordship.
I have no objection.
No objection?
The matter may place next week.
Huh?
Next week.
See.
Lordship,
What is the matter about, Mr. Hiral?
The matter pertains to appointment on the basis of land ownership.
Oh, we should
Yes.
take it up. This needs to be clear. There's always a big problem which we are finding every time a writ petition is filed on the basis. So we'll have it next week.
Lordship,
Ask your counsel or I ask anybody else to appear on behalf of the respondent number 5.
Lordship,
No further adjournments.
Lordship.
Okay. At the request of the learned counsel appearing on behalf of the respondent number 5, the matter stands adjourned to be listed again on 3rd of June 2026. It is observed that there shall be no further granting of adjournment on the next date.
Obliged, Lordship.
From the supplementary cost list for motion, item number 15.
With these lordships. My lord, before I start, I would like to bring to the attention of this noble court that in my synopsis, there's been a slight typographical error, my lord. In my synopsis. In the petition, it's
Mr. Counsel, we cannot allow this petition. We have to withdraw the petition. Who is the person detained?
the detainee is Mustaq here, my lord.
What is his name?
Mustaq, my lord.
Mustaq?
Yes, my lord.
Where is he?
The
Mr. Mustaq.
page number 4, my lord.
Mohammed Mustaq.
Yes, my lord.
Okay. And how is Mr. Anish connected?
He is the cousin brother of Mustaq, my lord. Yes, he is authorized to, the Mustaq has authorized him to file this application, my lord.
Now, what is the problem? with
Authorization
your
letter is-
synopsis? The synopsis, Mr. Sophie, we are not bothered. You argue a matter. You are not concerned with the synopsis. You argue the matter.
Fine, my lord.
The petition is otherwise okay.
Fine, my lord.
Fantastic.
My lord, the petitioner herein is seeking for revocation of the detention order dated 27 October 2025. The confirmation order dated 28 January 2026. And the order dated 28 April 2026, my lord.
So you were detained on 27th of October.
Yes, my lord.
And what is your ground?
My lord, my ground is amongst other ground, I would like to take the attention of this honorable court to page number 35, my lord. The order dated 28 April 2026.
35. Yes.
Page number 35, my lord.
Hmm.
As per this order, the state government exercising the power under section 9, clause F of the PIT-NDPS Act has further detained me for a period of 3 months, my lord.
Hmm.
From 29/4/2026 till 28/7/2026, my lord.
Hmm.
However, my lord, as per section 9, clause F of the PIT-NDPS Act, it is on the report of the advisory board, the state government may detain me. But here, it was on the report of the additional Director General of Police. Based on the report of the additional Director of General of Police, the state government has passed this, the extension of the
So your case is that 9F can only be exercised upon the report of the advisory board.
Yes, my lord.
Without the report of the advisory board, 9F cannot be exercised.
Yes, my lord.
That's all.
Yes, my lord. Yes, my lord. That is one of my contention.
So that would nullify the confirmation order.
No, my lord. This is the extension order.
This is also a confirmation why the order.
The confirmation order is dated.
Or this is an extension order.
Yes, my lord.
Okay, as of now, there is no report of the advisory board.
No, advisory board has given a report, and on the basis of the report of the advisory board, the state government has confirmed the detention order dated 28 January 2026.
Then
Then after again, on the expiry of that period, I was detained for 3 months. On expiry, again, they passed another order, 28 April 2026, and this order is without any authority, my lord.
Why?
Because my lord, section, clause F,
Let's see.
section 9,
Give us the PTNDPs.
Detainee's name is Mushtaq, but
Yes, ma'am.
here in your ghost title, it is written Amin.
no, my lord, that would be, that is WPC 16, my lord.
We are
One is
concerned with
15, 15, my lord.
In 15,
15 is Mustaq and 16 will be Amin.
So anyway, so it is the same person who has filed both.
Yes, my lord.
They're cousin brothers.
Yes, my lord. May I read, my lord?
Wait, let us find out. Ah, got it. Yes.
Section 9, clause F.
Yes, tell me.
So, my lord, as per section 9, clause F, based on the report of an advisory board, the government may confirm the detention order and continue the detention of a person concerned for such period, my lord, as it seems fit. But now, as per the order dated 28 April 2026, it was based on the report of the Additional Director General of Police, who is not the advisory board.
No, there is already, this is a 9F is for the purpose of confirmation.
Yes, my lord.
So they have confirmed on the basis of the advisory board's
Yes, my lord.
recommendation.
That is
Now,
already.
where do you find that for the purpose of thereafter extension, again, you require an advisory board's confirmation?
My
In
lord.
fact, it says here that if you go further,
Yes, my lord.
if there is an advisory board at a later point of time comes up and gives an opinion that the further detention is not required, you have to therefore close it.
Yes, my lord.
So therefore, that aspect is there. But where is it said that for the purpose of extension beyond the period of 3 months, which was there at the time of confirmation,
Yes, my lord.
there is a requirement of the advisory board's opinion?
My lord, based on the report of the advisory board, they have already issued a confirmation order.
Understood. So
But beyond
therefore,
that now, my lord.
my question, our question is, where is it mentioned in 9.5 that for the purpose of extension, you require the advisory board's again reiteration of the
My lord, it is
confirmation?
not mentioned, my lord. However, my lord, they have invoked section 9F to detain me further, my lord.
No, it is an extension
Yes, my lord.
because the power
And
may
that should
confirm
be
the detention order and continue the detention of the person
Yes.
so and so and so and so. The appropriate shall revoke it. Now, whether it is under 9.5, but they have the power to extend.
My lord, based on the report of the advisory board, not on the report of the Additional Director General of Police. As per
No,
F.
this is not on the basis of that.
Yes, my
You
lord.
see,
it is on the
no,
basis
they say, no, you don't require. You see, the confirmation order is based upon the advisory board's recommendation.
Yes, my lord.
Now, therefore, in exercise of 9F, hereby confirm the detention, which is at page 31.
Yes.
So, therefore, this is for this period. Thereupon, they say that it is further required because otherwise, where is their application of mind? When you submit, there is a requirement under the PNDPS Act that it has to be sent to the advisory board.
Yes, my lord.
Advisory board was duly mentioned. Advisory board came up with a recommendation to that effect that yes, his detention is required. On the basis of that, they have confirmed it. Okay. Now, thereupon, any extension is required. There is no requirement of an advisory boards.
But my lord, they've invoked their powers under section
No,
9F.
Mr. Sophie, that is not the case. No,
And based on the recommendation of the Additional Director General of Police.
they 9F, they otherwise have the power. The power is there for a period of 1 year. But
Yes.
when you see on what basis would they extend? They have to again extend every time they cannot ask the advisory board for again a concurrence. So they have to have materials. So the materials is that this is a report being submitted that after 3 months also we have considered this and this is the material placed before us that his extension is required.
Lord, they don't have
Anyways,
authorization, my humble submission.
we do one thing, it's a case of habeas corpus, we
Yes.
issue a notice to
I
him
know.
and let them file an affidavit. But is this the only point?
No, my lord.
Which else?
I have two other points, my lord.
Which other?
That it is not to the subjective satisfaction of the detaining authority. As I've been working under a commercial quantity of the PTNDPS, this NDPS, and the authority can detain me for 1 year, even without issuing me this detention under PTNDPS, under section 36A, my lord. They can further detain me for 1 year, even without issuing.
So you are otherwise in jail.
Yes, my lord.
So you are, therefore, your cases would come within the ambit that there is no subjective satisfaction
Yes, my lord.
that you are likely to be
Bail is
enlarged on
reduced.
bail at the time of detention.
Yes,
That is
ma'am.
your case,
Yes,
which is all the various judgments that we have delivered,
Yes, my lord.
isn't it?
Yes.
And you should notice making it returnable on we have it on 10th of June.
Yes, Your Lordship.
You produce the records and file, and in the meantime, file your affidavit.
Yes, Your Lordship.
You should notice making it returnable on 10th of June 2026. Ms. So-and-so
I'll be representing 1, 3, and 4.
accepts notice on 1, 3, and 4.
Yes, Your Lordship.
3 and 4, no? There's no 5.
Okay, my lord.
1, 3, and 4.
1, 2, and 4.
Mr. Nuguli
Yes, my lord.
accepts notice on behalf of the respondent number 2. Extra copies of the writ petition be served upon the learned counsels appearing on behalf of the respondents during the course of the day. The petitioner herein, who is the cousin brother of the detinue, Sri Mustaq, you find the name at page number 4. In both the cases, this will be the same order, but just name. Have challenged the detention order dated 27/10/2025, the confirmation order dated 28/1/2026, as well as the extension order dated 28/4/2026. On various grounds, including the grounds that the extension which was granted on 28/4/2026 is in violation to section 9F of the Prevention of Illicit Traffic in Narcotic Drugs and Psychopathic Substances Act 1988, for short, the Act of 1988. It is the contention of the learned counsel appearing on behalf of the petitioner that for the purpose of extension also, there is a requirement of obtaining the opinion from the advisory board. And without that, section 9F cannot be of the Act of 1988 cannot be put into service. Additionally, the learned counsel appearing on behalf of the petitioner submits that the petitioner, that the detinue was arrested on
30/08/2025.
38/2025, isn't it?
Yes, my lord. 38 to
38/2025. Under section 20 small b Roman 2 bracket capital C of the Narcotic Drugs and Psychopathic Substance Act 1985, which involves commercial quantity. Under such circumstances, there was no necessity for detention of the detinue without there being a subjective satisfaction that the detainee was likely to be enlarged on bail, more so in view of the mandatory requirement, in view of the twin conditions mentioned in section 37 of the Act of 1985. Taking into account the above, the respondents herein are directed to bring on record their stand by filing the affidavit on or before 8th of June 2026, so that the instant proceedings can be taken up for disposal on 10th of June 2026. The records also be produced pertaining to the detention of the detainee in question. Same order for the other two, 15 and 16. Same order. Same day arrested.
Same day arrested.
Brothers, they are brothers,
Yes, my lord.
arrested together.
Arrested together.
And now the cousin brother has come for help.
Yes, my lord.
For admission, item number 1.
Mr. Lordships.
Hmm.
Lordship, in compliance of this court order, we have filed a affidavit, Lordship, with regard to the action plan.
Any order passed by me in this matter?
No, Lordship.
No. Okay.
Lordship, the order was dated 4/12/2025. 4/12/2025.
Bench and affidavit has been filed with us. Enough, 7 months.
So we were directed to
So I
The-
think this order of 4/12/2025 is
Lordship.
to elaborate.
Lordships.
What actions have been taken?
Yes, Lordship. Lordship, may I kindly come to my affidavit? I filed this affidavit on the 1st April 2026 affidavit, Lordship.
Where?
1st April. The affidavit or respondent number 1, 2, 3, and 4, Lordship.
1st April.
Yes, Lordship. Lordship as well, Lordships.
Yes.
Page 3, paragraph 4, Lordship. More particularly, paragraph 3 also, Lordship. So the roadmap has been prepared, keeping in view of the guidelines of the ministry, Lordship, and as well as the guidelines of the NACO, National AIDS Control Organization. Lordship, will kindly come to page 6. Yes. 5 is the letter, 6 is the roadmap, Lordship. Now, Lordship, may kindly come to page 8, the long-term plan. This is the actual action plan that we are working on it, Lordship. And this has been deliberated at the government level, Lordship. Long-term plan, Lordship. C. To set up blood bank in district hospitals with high cases load or where access to blood from the licensed blood bank is difficult due to distance. 2. Introduce post-MBBS diploma course in pathology under the National Board of Examination in Medical Sciences at NHK, that is Naga Hospital, Kohima, Lordship, and other district hospitals. Gap assessment of human resource, training need, infrastructure, equipment, and other logistic as per the requirement of the Act. Based on the gap assessment, initiate development of infrastructure, equipment, and other logistic in the identified hospitals.
And what about 6A? 6A, page 7.
Page 7, Lordship. Yes.
Let's see, read six. The
Six.
annual collection of blood.
The annual collection of blood in the aforementioned Lances Blood Bank and the Blood Storage Center is 10,000 units. And considering the requirement of blood in other hospitals without blood bank or blood storage center and the shortage of specialist manpower, roadmap increasing the number of specialists in blood transfusion and setting up of at least one blood storage center in each district hospital are as follows. A, the blood storage centers. Set up blood storage centers in all district hospitals and first referral units, that FRU, without blood banks. Undertake gap assessment of human resource, training need, infrastructure, equipment, and other logistics as per the requirement of the Act. Based on the gap assessment.
So this is what you want to do in future.
Yes, Lordship. Now that it has been rolled out. It has been rolled out, already rolled out.
Huh?
Already worked on it, Lordship. So we have,
This
yes.
has happened. A and B has already.
Yes, it's happening, Lordship. Because in fact, there was a review meeting of the department 2 weeks back. So this was focused, Lordship. This requirement was focused. And the concerned section of the department dealing with the blood bank has been asked to work out on this, Lordship, recently.
They have been asked to proceed with this.
Yes, proceed with this, Lordship.
So if this is then done, then obviously the petitioner's case is being taken.
Yes, Lordship, yes.
We close the PIL
Lordship,
and by quoting this particular,
Lordship, yes.
and this should be done. And if it is not done,
Yes,
leave it
Lordship,
open to the
yes.
petitioner to again.
Yes, Lordship.
Lordship, yes. Lordship, I just have a few clarification. As per the affidavit 10/2/2025, in paragraph 3, they have stated that with the direction of this court, now 4 blood banks have been set up. Trengsang, Kifri, Mon, and Pek. But in the recent affidavit file, they have said that only 3 blood banks are functional in the state. So, Lordship, if the
Presently, there are, kindly come to page 6.
Lordship, yes.
Presently, there are 3 licensed blood centers. So and so, so and so, so and so. There are 6 blood storage centers. So this is what they say.
Lordship, yes.
So therefore, they mention these. So this is their stand which they have taken.
Lordship,
So we incorporate it in our order, the entire thing what they have said. And
Lordship,
what
yes.
Mr. Mujoy says now,
Lordship.
that they are incorporating or implementing the requirement in terms with 6A and B.
Lordship, yes.
So therefore, we cannot oversee whether it has been done in what manner.
Lordship.
But if you don't get the benefit
Lordship,
Yes.
after some time, you can always approach this.
Yes.
Lordship, yes.
That is the
So I would
way.
pray,
Because keeping the matter pending, we can't go into so much details. What do you say?
Lordship, yes, I agree.
We can't.
I agree, Lordship. So
And-
I would
and
request,
this will be taken as a stand. You see, this has been given by the prince under the signature of the principal director, health and family. So we asked him to do the needful in terms with the undertaking.
Yes,
We
Lordship.
will consider this to be an undertaking to us.
Yes.
Lordship, yes.
This is in the form of
Lordship.
an affidavit, Lordship.
Yes.
Yes, it's an undertaking.
An undertaking to us, and
Lordship,
once it is an undertaking to us, if they don't do it, they know what is the consequence.
Yes, Lordship.
Lordship, yes, I am obliged, Lordship. However, Lordship, I would also pray that this court may kindly appreciate the affidavit filed by the central government as well, Lordship. More particularly on paragraph 4, Lordship.
The-
When, yes, affidavit dated 6 February 2024, Lordship. Respondent number 5, who is the
February 2023.
national, yes, representing National Blood Transfusion Council, Lordship.
Where? Filed by respondent number 5.
Lordship, yes.
Huh?
Affidavit dated 6 February 2024.
We don't have an affidavit of 6 February 2024.
Lordship, yes.
This is filed by one Pampos Pokhriel.
Yes, Lordship Pampos Procrial, he is the representing respondent number 5, Lordship.
Yes, what did they say?
So, para 4, Lordship, particularly on that, they have. Lordship, they also not in denial that every district should have a blood bank, Lordship.
There is no denial to that effect.
Yes, Lordship, and they said that,
We also will not deny that effect.
they also said that they said that there should be at least one blood bank per district, The Government of India adopted a national blood policy, which aims to develop a nationwide system to ensure. And also, they also mentioned that in case of unable to have this blood bank, there should be a blood storage center should be there.
Where?
Lara?
No, there is a requirement of the blood bank is, this is on the basis of they are already having a circular. Now, what do you say about the affidavit, Mr. Mujoy?
Lordship.
You have filed an affidavit on 10th of February 2025. It is signed by one aforesaid.
10th of February 2024.
This is signed by on 31st of January 2025, but filed on here. Now, in this affidavit at paragraph number 3, you categorically mentioned that with regard to the direction of this court, the answering deponent begs to state that besides the newly set up blood banks at Winsang, Kifri, Mon, and Pek, the other existing blood centers, banks are Naga Hospital, so and so, this is another 6. The existing blood storage centers are at so and so. 1, 2, 3, 4, 5, 6.
Lordship.
You got it?
Lordship, yes, Lordship.
Okay?
Lordship. Paragraph 3, Lordship.
Yes.
Yes.
So this is as on 2025.
25, Lordship.
Now, in the annexure 1, which you have mentioned, if you see, kindly come to paragraph 3 of that affidavit
Lordships.
and conjointly read with annexure 1 of the affidavit which have been filed recently
Lordships.
on 1/4/2026.
Lordship.
Lordship.
You will see that you say that besides the newly set up blood banks at Winsang, Kifri, Mon, and Pek, you
Lordship.
get it? Paragraph 3.
Lordships.
Madam, you have a copy of the affidavit?
Lordship, yes, I have.
Kindly give it to Mr. Mujoy.
Lordship, I have.
He found it, Lordship.
Okay. So that besides the newly set up blood bank at Winsang, Kifri, Mon, and Pek,
Yes.
the other existing blood centers
Lordship.
are so and so. Okay.
Lordships.
Now let us conjointly read out here. Here you say, presently there are 3 licensed blood centers.
Lordships.
So and so, so and so, so and so. Isn't it?
Yes. Lordship, may kindly come to page 6 of the recent affidavit, Lordship.
That is what I'm saying.
Yes.
Here now in the page 6, you say there are 3 licensed blood centers.
Lordship. Lordship,
How do you take care of this?
yes, Lordship. Lordship, may
You
kindly
are
come
saying
to.
blood center banks are at so and so, so and so. This is 6.
Yes.
You are
Lordship,
saying here, what is there?
Christian
This is,
Institute.
Nak, Dimapur District Hospital, Dimapur Mokoksong, 1 licensed blood center at private
There are 3.
hospital, Christian Medical.
NHK, Dimapur, and Mohotu.
So this is therefore 6.
Yes. Now the other 3 are 2 are Army, Lordship, Army Hospital, and 1 is a private hospital. Referral hospital.
But army is not under you.
No. They take the license from the department, Lordship, from the.
But would a civilian be able to get the benefits there?
Yes, Lordship, because they're all tied up, Lordship. In case of requirements,
Okay.
like even private hospitals, they take up from us.
They take up from us, so that is 1.
Yes.
But are you able to get it from the private?
Yes, Lordship. We are able to get it. Yes, Lordship. That's why we have mentioned this other 3 hospitals.
Existing blood centers are at so and so.
3 in
So,
the
so therefore, in 2000, from 2025 to 26,
Lordship.
1 year has gone, there is no improvement.
Lordship, this issue we have already explained to the court because we need to at least have 2,000 consumption unit annually to have a licensed blood center.
Okay.
So unless we fulfill that requirement, Lordship, we don't qualify.
Have you mentioned in Annexure 1 out here?
Lordship, I have stated in my previous affidavits.
Annual collection of blood in the aforementioned lands.
So in the three blood license, Lordship, our annual collection is 10,000 units.
Annual collection is
10,000 units, yes, which we have mentioned in the recent affidavit, Lordship.
That I've seen. In fact, the same was also mentioned earlier.
Lordship, we have not mentioned the overall, but we have mentioned about the annual collection.
Okay. But this is as per the drugs and cosmetics rules,
Yes, Lordship, 1945.
form of license of operation of whole consumer.
Lorships. In fact, in the same affidavit of 2025, we have annexed the rules, Lordship. More specifically, the provisions.
Okay. Okay, we close it then.
Lordships.
Lordship, yes. If, Lordship, I appreciate the state effort also, Lordship, regarding the action taken and then steps taken and also the action taken report that has been placed before this court, Lordship. However, Lordship, since no timeline was given, Lordship, so if this court can also pass a direction.
We did ask them to do one thing to file that they are doing all these things.
Lordship, yes.
Let them file an updated compliance report as to what has happened. No, that is not required. We say that these, he has mentioned that these are now being taken up.
Lordship,
And
yes.
they have already started.
Lordship,
So if they have started, obviously this will take some time.
Lordship.
Now, this time, if it is required out there, obviously, if it is, you are not in a position to get it, then obviously you will have.
Yes,
to-
Lordship. Yes, definitely.
But we cannot keep a matter pending just for the sake that they will do one day or not.
I agree,
If they
Lordship.
don't do it, this is an undertaking. This is an undertaking given before the
Lord-
court.
yes.
And
Lordship,
Mr.
yes.
Mujo has further submitted that in pursuance to this undertaking, they have put it into action by holding a meeting on.
Lordship, it was 2 weeks back, Lordship, 2 weeks back.
Okay, by the time I finish my dictation, you give the date.
Lordship, I can give you. Lordship. So if Lordship can excuse
Yes,
me for 2 minutes,
please.
I'll confirm the date.
Okay, no problem. Let
Lordship,
me
also,
start.
just a kindly, a small prayer, Lordship. Here, Lordship,
Madam,
yes.
you have better things to do today. You have other bigger matters. So we now have to see that you are not further being troubled with this type of matters. The other matters you do a lot of PIL, so therefore you have to concentrate in other aspects which are now requiring bigger attention of this thing. Heard Ms. So-and-so, the learned counsel appearing on behalf of the petitioners. Mr. N. Mujoy appears on behalf of the respondent numbers 1, 2, 3, 4, 5, and Mr. Yangavati appears for the respondent number 6. The present public interest litigation is being initiated at the instance of the petitioners. Drawing the attention of this court to the gaps and poor health facilities in the state of Nagaland on account of the absence of blood banks in some of the districts in Nagaland. By their present PIL, further, the petitioners have sought to draw the attention of us to the lack of adequate access to blood for transfusion purpose and a shortage and disproportionate distribution of establishment of blood storage units in the state of Nagaland, in contradiction to the national blood policy and the NBTC guidelines to have at least one blood bank per district, especially for the vulnerable sections of the society in rural areas. The records reveal that this court, being satisfied with the locus of the petitioners, proceeded with the entertained the instant with petition, instant public interest litigation, by an order dated 15/9/2021. The record reveals that on I don't know, where is the first affidavit file? Well, that on 3rd of May 2023, an affidavit in opposition was filed by the respondent numbers 2 to 4. Wherein it was mentioned that as a matter of procedure to set up a blood component separator in the district hospital, the concerned district hospital should be a registered blood bank. Further to that, it was mentioned that to have a blood component separator in the district hospital, the government has to apply for license through the Central License Approving Authority. And only after inspection and approval by the authority, the license would be granted. The blood component separator have been procured at NAC. And since the state does not have the qualified technician to mend the machines, an in-service lab technician at NAC was sent for training, and after completing the course to mend the blood component separator, he had already joined the post. Insofar as setting up of a blood component separator at Eastern Nagaland, it was mentioned that there is no registered blood bank in Eastern Nagaland. However, the Government of India, through the Ministry of Development of Northeastern Region, have accorded administrative and financial sanction under the Northeast Special Infrastructure Development Scheme for setting up of the blood bank in Eastern Nagaland at District Hospital of Tuenseng, Kifri and Mon, including the District Hospital Pek by letter dated 2/7/2020. This court finds it very pertinent to take note of an affidavit filed by the respondent numbers 1 to 4 on 10th of February 2025.
No, sir.
In the said affidavit, additional affidavit was filed in pursuance to an order passed by us on 13/11/2024,
No, sir.
whereby directions were given to the state respondents to file a detailed affidavit placing the status of existence or availability of blood center (bank) as well as blood storage units in all the 17 districts of the state of Nagaland. In pursuance to that, the affidavit, which was filed on 10th of February 2025, contained details to the effect that besides that as on the date on filing of the agreement affidavit, there were existing blood center (bank) at number 1 Naga Hospital Authority Kohima (NHAK). Number 2 Dimapur District Hospital Dimapur. Number 3 Dr. Imhongliba Memorial District Hospital Mokokchung. Number 4 Christian Institute of Health Science and Research Dimapur. Number 5 154 Army General Hospital Jakhama Kohima. And number 6 165 Army Hospital Rangapara Dimapur. In addition to that, it was mentioned that newly blood banks were set up at Twinsang, Tifri, Mon, and Pek. It was also mentioned in the state affidavit that the existing blood storage centers were at number 1, CHC Jaluki Peren, number 2, CHC Mejifima Chubukidima, number 3, District Hospital Mon, number 4, District Hospital Woka, number 5, District Hospital Kifri, and number 6, Hejuku Memorial District Hospital Junubeto. Apart from that, what the blood banks, blood center (bank) as well as the blood storage centers were catering to have also been mentioned in detail at paragraph number 4 and 5. This court also takes note of. We also take note of the affidavit in opposition filed by the respondent number 5, that is the Union of India. Wherein, filed by the Union of India on 13th of March 2024. In the said affidavit, it was mentioned that for the purpose of strengthening public health facilities, it is the state government's responsibility. And as such, the government of India does not directly approve proposal for setting up strengthening of the state public health facilities under the National Health Mission (NHM). The Ministry of Health and Family Welfare provides financial sanction and technical support to the states' public utility governments for strengthening of their healthcare systems within their resource envelope based on the proposals received from them in their program implementation plans. In the said affidavit, there was mention to the Blood Transfusion Service (BTS) and the National Blood Transfusion Council (NBTC). And the work carried out by those authorities. In addition to that, in the said affidavit, it was mentioned that based upon proposals submitted by the state governments throughout the country.
Lordship.
By the states throughout the country. Through the National Health Mission, the Government of India through blood transfusion services also supports 1131 blood banks in public and charitable sector in respect of manpower, procurement of blood bags and testing kits, conducting voluntary blood donation camps and information, education, communications, activities, etc. In addition to that, mobile vans for blood collection and blood transportation vans are provided to the states/union territories. This court finds it relevant. So we also find it relevant to take note of the order passed on
This is the last meeting that was Lordship mentioned.
4/12/2025 by the learned coordinate bench of this court.
Okay.
Whereby by the learned coordinate bench of this, whereby the respondent numbers 1 to 4 were directed to inform this court about the efforts made / measures adopted by the authorities to mitigate the crisis in case of necessity / emergent situations. In case the number of specialists in blood transmission in blood storage centers is not adequate. This court further directed that a detailed roadmap of the health department regarding increasing the number of specialists in blood transfusion and setting up of at least one blood storage center in one hospital in each district in the state of Nagaland be placed before this court. In pursuance thereto, an affidavit has been filed on 1st of February 2020, 1st of April 2026 by the Principal Director, Department of Health and Family Welfare, Nagaland. In the same affidavit which was filed, the roadmap as mentioned, the roadmap for increasing the number of specialists in blood transfusion and setting up of at least one blood storage center in one hospital in each district in the state of Nagaland have been mentioned in Annexure 1, Roman 1. Roman 1?
It's one.
Annexure 1 to the said affidavit. Taking into account the contents of the roadmap has significance in the present, in the issue which this court is dealing with, this court reproduces the entire contents of Annexure 1 to the present proceed in the contents of the Annexure 1 hereunder. From a perusal of the above quoted contents, it is, and more particularly, Clause 6 of Annexure 1 mentions as to how the number of specialists in blood transfusion and setting up of at least one blood storage center in each district hospital would be carried out. This court, we would construe the contents of Annexure 1, which is based upon an affidavit filed by the Principal Director, Health and Family Welfare Nagaland to be an undertaking given to us by the state of Nagaland with undertaking that the said roadmap would be and the steps which are required for the purpose of increasing the number of specialists in blood transfusion and setting up of at least one blood storage center in each district in Nagaland would be implemented.
Also, Lordship, blood component
In this
separation.
regard, this court further finds it relevant to take note of that in pursuance to the said roadmap which have been placed before us by the affidavit dated 1/4/2026, a meeting was held on 18th of May 2026 in the conference hall of Health and Family Welfare Department for implementation of the roadmap which have been placed before us relating to increasing the number of specialists in blood transfusion and setting up of at least one blood storage center in each district hospital in the state. Mr. Mujoy, the learned counsel appearing on behalf of the respondent numbers 1 to 4, submits that for the purpose of implementation of the roadmap as have been given, roadmap, the undertaking of which have been given before this court, the respondent authorities in the state would also require to seek assistance from the state center. This court have duly taken note of the affidavit which have been filed by the Government of India by the respondent number 5, wherein it is said by the Government of India that on the basis of requests being made by the states through their NHMs, required assistance is being provided. We are of the view that it is the requirement of law that in every district there should be a blood, what is that?
Storage center.
Storage center. And more particularly in the state of Nagaland, taking into account the terrain and the difficulty from traveling from one district to the other. First, we are also of the view that having just blood storage centers would not be sufficient. There has to be specialists appointed in blood transfusion for the purpose of
Manning those blood centers, Lordship.
for the purpose of making use of the establishment of the blood storage centers.
Lordship.
The state, who is the implementing agency, who is the state of Nagaland, being the authority in terms with the constitution, which in respect to the subject health would be required to do the needful so that on account of lack of facilities or lack of specialists in blood transfusion, the citizens do not suffer. We take we duly take note of that for the purpose of implementing the roadmap, it is the authorities in the state as well as the center who have to work together. This we hope and expect that in terms with the undertaking given to us, which is Annexure 1 to the affidavit filed on 1/4/2026, the respondent authorities shall do the needful.
Lordship.
It is observed that in the circumstance, there is another. Accordingly, we close the instant public interest litigation, taking into account the steps which have been taken and placed before this court. However, while closing the instant public interest litigation, we direct as hereunder. The respondents herein, more particularly the Health and Family Welfare Department of the Government of Nagaland, is directed to take appropriate steps as per the roadmap given before us, thereby ensuring that there should be a blood storage center in each district in the state of Nagaland.
Lordship.
We further direct the respondents numbers 1 to 4 to take appropriate steps for increasing the number of specialists in blood transfusion who can be transfusion, as in their absence, the blood storage centers would not be workable. Next. We further direct that the respondent number 5 shall also provide necessary assistance, thereby ensuring that necessary assistance as permissible as per their guidelines to the state of Nagaland, so that each district hospital in the state of Nagaland can have a blood storage center and employ specialists in blood transfusion. The state direction shall be subject to the state of Nagaland fulfilling the criteria for the financial assistance from this union. Next. An affidavit of compliance to the aforesaid directions and further actions which have been taken be filed by the principal director or principal secretary.
Lordship, it will be appropriate for the government to file.
Principal secretary.
Principal Secretary.
Be filed by the principal secretary.
Commissioner Secretary.
Huh?
Commissioner Secretary. We have
Commissioner and Secretary, Department of Health and Family Welfare Department, Welfare, Nagaland. On or before January 19th, 2027.
Lordship.
Next. Before parting with the record, we would like to observe that The closure of the instant public interest litigation is on the basis that due steps have been taken, on the basis that attention has been drawn to us that due steps have been taken by the state of Nagaland, and further steps would be taken. Due steps have been taken, and further steps would be taken by the state of Nagaland for setting up of blood storage centers in each district hospital in the state of Nagaland. However, the closure of the instant petition public shall not prejudice the petitioners to again approach this court post January 2027 in the circumstance that there is no compliance to the aforementioned directions. First, next. We express our gratitude to Ms. So-and-so, who represents the petitioner, for bringing the attention of this court to the by way of the present public interest.
Obliged.
From the supplementary cost list for admission, item number 17.
What is this? Huh? What is it?
Compassionate appointment.
Yes, Your Lordship. Your Lordships, this is an appeal against the judgment order dated 5/5/2026, passed by the learned single judge in WPC 68 of 2026, whereby the writ petition of the appellant came to be dismissed. Your Lordship, the appellant's father died while in harness in the year 23/8/2009. And immediately thereafter, the appellant made an application under the compassionate scheme, and the application was submitted in the year 10/9/2009. And Your Lordship, here, the competent authority has also categorically marked in the application of the applicant as a compassionate case, while entering the necessary pursual and actions. However, Your Lordships, the department give the appellant under the casual scheme, under that casual, and not in the compassionate appointment, not the regular. Your Lordships, the earlier writ petitions, number that is 14 of 2026, was disposed directing the considerations of the representations. However, the authority rejected on the points that on the points for appointment seniority and vacancy grounds, without appreciating that the applicant original entry likely arose out of compassionate circumstances. Your Lordship, then the learned single judge, with utmost respect, failed to appreciate that the appellant's compassionate claim cannot be defeated merely because she was temporarily adjusted on a mutual basis, and that the appellant compassionate claim was merely a genuine consideration. Therefore, Your Lordship, the only grievances of the appellant is that she should be appointed on compassionate ground instead of casual basis.
What is your age?
At present, my age is 36, Your Lordship.
36.
Yes.
You are now being brought under the There's some OM of 2024. Where's the OM of 2024? Or is it huh? Madam, there's a reference to some. Is it the 2004 or 2024? Huh, Mr. Jimomi?
But
The order passed by the learned single judge
signatory.
refers to some OM of 2024. 28/8/2024. Is it 24 or 2004? What is this OM? For regularization, there are two.
Lordship,
One is of 16/9/2004,
Lordship.
and the other is 17/3/2015.
Yes.
That I know. One is another one bringing scale of pay is 5/3/2025. What is this 2024? Must be something to do with a compassionate appointment. Compassionate appointment is 17/9/2015.
2016.
Thereafter, there is some amendment made in 2024, but this order passed by the learned single judge on the basis and terms with office memorandum dated 28/8/2024. What is this? Madam?
Lordship, this is for the scheme for regularization. I think this is for the scheme for regularization, office memorandum dated 28/8/2023.
Where is that?
But the office memorandum is
next?
2015.
That has not been annexed. However, I think that is to do with the scheme for regularization, Lordship. Scheme for regularization. Yes.
Now, Mr.
For
Jimomi, tell me
regularization on
one
our
thing.
service in term of office memorandum.
Because she has relied on the 17/9/2015.
Lordship, here is a case
Yeah, the
where,
father died in 2009.
Lordship,
At that point of time, did you have any compassionate appointment scheme?
Lordship, in fact, the contention of the state respondent is that the appellant, the petitioner, she was not appointed on the compassionate ground.
That I know.
Lordship,
No, if I detail out the facts, which I could read it out here is,
Lordship,
father died on
2009.
25/8/2009.
9. Lordship,
On 10/9/2009, she filed the application. Then, in the year 2012, she was appointed as a casual khalasi.
Lordship,
She continued, and thereupon, she filed an application for regularization.
Lordship,
That regularization was not granted.
Not
Her
granted.
regularization application is on the basis of a compassionate appointment, which
Lordship,
obviously she has done so on a mistaken advice. Obviously, there cannot be a regularization by way of a compassionate appointment. That is not permissible.
Lordship,
So therefore, they say that we will consider you when your time arises as per your seniority.
Lordship,
Now, this seniority, if I know, is on the basis of that 2004. The
2004.
2004 Office Memorandum, which is the 15/9 of the year, categorically mentions on vacancy being arising, 50% of the vacancy being arising.
No.
This would be 50% would be filled up by way of regularization on the basis of existence of a post. The post has to be in existence
Lordship,
and on the basis of seniority.
Lordship,
Her seniority is 26. So
her
she cannot
seniority.
get on unless there is what has happened. This is her case. But what is this 2024? I don't get it.
Lordship, I think this must be the,
I've also
This-
never heard it.
Lordship, this must be the typing mistake, or else it could happen in 2004 instead of. There is a 2004 office memorandum for
Maybe it's there,
regularization.
but 28/8/2024, we have not.
And you, in the meantime, find out whether in 2009, when the petitioner's father expired, when she filed the application, whether there was a policy for on compassionate grounds.
Your Lordship, here, if there were no appointment for
No,
commission.
madam, you have to try your hard, not like this.
Lordship, Lordship, to make it very clear, Lordship may kindly come to page 84, Lordship.
Okay?
84 of the appeal memo. Lordship, we have replied to the appellant petitioner, Lordship. And we have clearly stated, Lordship, 84 annexure 11. This is the letter which have been communicated to the appellant petitioner.
Now, this is it. Kindly see, in accordance with the OM dated 28/8/2024.
Lordship,
What is that?
Lordship, I will just try to shout this office.
You
member.
produce.
Lordship.
We do one thing, we admit this. We pick up for final disposal next week.
Lordship,
The issue, in the meantime, you produce this.
Lordship. Since they have not annexed this office member, since they have not annexed this office member.
Heard Ms. So-and-so, the learned counsel appearing on behalf of the appellant. Mr. So-and-so who appears on behalf of the respondent numbers 1 to 4. The present writ appeal arises out of is filed challenging the judgment and order passed by the learned single judge. Dated 5/5/2026, passed in WPC number 68/2026. We admit the appeal. First, the instant appeal be directed for final disposal on
Next week.
next week 10th, huh? Not 10th, it is on 3rd, no? What is it? On 3rd, yeah. We admit the appeal. Mr. V. Jimomi accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the writ appeal be provided to him during the course of the day. First, we have also perused the impugned judgment and order dated 5/5/2026. And in the said judgment and order, there is a reference to an office memorandum dated 28/8/2024. However, we do not find the said office memorandum in the records.
Lord.
Mr. V. Chimomi, who appears on behalf of the respondent number 1 to 4, is directed to place the said office memorandum. Also, the registry shall also. You have the entire records here?
Yes, Your Lordship.
Or should we call the writ petition? Shall also tag the records of WPC number 68/2026 with the present writ appeal.
Yes, Your Lordship.
For orders, item numbers 2 and 3.
It has come up for
For last occasion, registry was directed to appoint legal aid counsel for the complainant, who is respondent number 2.
then,
So, Lordship, and for.
where is the order?
She don't come back for this.
You are there?
Yes, my lord.
Then,
As legal aid counsel
fantastic.
for the appellant.
So now everything in paper book is ready.
Yes, my lord.
Lordship, we have not received a copy of the paper book.
You are for?
Respondent number 2.
I'll
I'll
late counsel, Lordship.
furnish him within the course of the week, my lord.
Who?
The paper proof.
You cannot give it. You are a
The
legal
registry
aid.
will give.
Oh, yes. Adam, you have to be. Yeah, otherwise there's so many other matters, no? He's a very well-to-do counsel, so he deal from his own pocket.
No, my lord,
Yesterday, Monday, I found him having 8 matters. Yesterday, my entire list was filled up with 8 matters. Where do you give it?
no, my lord, if my lord so pleases,
So usually the practice is
yes, 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 in order to expedite the
Registry
hearing,
will give it.
the hearing of the case, my lord, I actually, if
It's
I
okay.
can
You
let
can
photocopies and provide.
direct the registry to give it.
My lord, my
and,
lord.
Fixing for final disposal on, if the person is inside, na?
My lord, my lord.
Where, what is the date of
Since
conviction?
2014,
2014.
yes, my lord, he has been sentenced to life imprisonment the till natural death, my lord,
The case of 302.
as well as 376, my lord.
Huh?
That as well as 376. POCSO as well, my lord.
Okay, let's have it on 10 for final disposal.
My lord, my lord, my lord.
My lord,
Mr. Santiago appears on.
Otherwise, I had come prepared, fully prepared for.
Who?
But they have not.
Yes,
received
my lord,
the
my lord,
So we keep it. We ask the registry to give it by this week.
my lord, my lord.
You have a copy of the paper book.
Yes, I do.
Okay,
I do.
And my
one
lord,
copy
is
will
my-
be given to him. You
Right.
go and collect it from the registry.
It's my humble prayer to reflect the name in the cost list.
Huh?
Reflect my name in the cost list, my lord.
You have filed a wakalatama? You are also legal aid.
Legal aid, my lord.
Yes,
I was
You are also
recently
legal aid.
appointed.
You are
Yes.
not a legal aid.
I am also legal aid.
Both legal aid.
Yes, my lord.
So and so, Mr. Sentienga appears on behalf of the appellant. Mr. K. Angami appears on behalf of the respondent state. Mr. So-and-so appears on behalf of the respondent number 2, the complainant. This court have also taken note of that the paper book have already been prepared. Mr. So-and-so, who appears for the respondent number 2, submits that he have not been provided with the paper book. So the registry is directed to provide a copy of the paper book within 3 days. By Monday next. Give the date, huh? Just taking into account that the appellant hearing
My lord.
is incarcerated pursuant to the judgment passed by the pursuant to the judgment and pursuant to the judgment impugned and the conviction for the last 12 years.
Yes, my
Well-
lord, my lord, my lord.
We find that the instant appeal requires an early disposal.
My lord.
Accordingly, lists this matter on 17th by 17th,
My lord.
17th of June 2026 for hearing. This
My lord.
accordingly for hearing.
Deeply obliged, my lord.
Appeal has been admitted, no?
Yes, my lord.
For orders, item number 4.
Please, my lord. Matter, the paper book is not completed yet.
Huh?
Paper book is not completed.
What is not completed?
It's complete.
Paper book is completed.
Paper book is
Then your
completed.
lordship, I'm here to receive that paper book.
Okay, both of you have not
There's been
received.
some issues.
Okay, the cow, Mr. Your name?
Purwa Panglakumar.
So and so. You are a legal aid.
No, this is not legal aid.
You're not a legal aid.
No.
Then it is your burden to prepare the paper book. Paper book is prepared. You go and collect it.
There's
You are the appellant.
transaction errors in the file.
You go and collect.
You have to pay. You have
Yes,
to
yes.
pay the.
You have
Yeah,
not
we
paid.
tried, yeah.
Have
There
you
was some
paid or
errors in
not?
the,
Have you paid or not?
no, we have not paid yet. There were some transaction errors. Recently, we went there to the treasury and accounts and the SBI heads were facing some issues. So we will do it today.
You're doing today. Miss Swans Esmeri, the learned government counsel. And there is another one, na? Miss
Yes. for respondent number 2.
2 and
But
3,
we
there is
not
somebody
around today.
appearing.
Yes.
The councils appearing on behalf of the respondents submits that they have not received the paper book. This court also takes note of that the paper book has already been prepared. The registry is directed to provide paper book to the respective councils appearing on behalf of the respondents as well as the appellants. The same, however, would be subject to payment of the amount, payment of the to be made by the appellant. The Mr. So-and-so appearing on behalf of the appellant submits that a payment will be made today. Stop. List this matter for hearing on 24th of June 2026.
For orders, item number 5.
Lordships, similar reason, Lordship. Similar,
Same case.
same. This is a legal,
Same on 24th, huh?
much of it.
For orders, item number 6.
Lordship, this is another legal services matter. It
Now, what
appears,
do you have?
steps upon the respondent number 2 is yet to be completed.
6. Paper book prepared,
Paper book.
payment not made.
Yes, I have sent my junior today to the treasury office to.
So same order,
For preparation
Same
of
order.
challan, my lord, my lord.
fix it on, we have it on
10th, my lord.
15th of July.
If it can be taken up on 10th, lordship,
Why?
10th of June.
What is the urgency? Because you don't pay.
No, lordship, we received,
Yes, this is the most important thing. You have not
we received
paid.
only recently, my lord, the letter. Because we are required to prepare 2 treasury challans.
So you
So
are
the
paying,
second-
you will be doing it today.
Yes, my junior is already in the treasury office.
Let us have it on 17th
My lord, my lord.
for hearing, huh? Same order, same.
My lord,
There is no other respondent, only one.
and,
Correspondent.
as regards respondent number 2,
Informant.
not the informant. Here, this is a peculiar case in the sense we are raising the ground that he was suffering from unsoundness of mind, insanity. He was conducted psychoanalysis by the doctors, psychiatrists at State Mental Hospital. Now, my lord, at page, why we have implemented the respondent number 2 is at page 90, my lord. They are saying that they have conducted 4 tests, but these were not exhibited. And the rule is that the patient himself who suffers
Wait. Now, appellants have not taken steps for service upon respondent number 2. Then, have you taken steps upon
Yes,
respondent?
my lord.
When? There's no mention anything.
I have the receipt also with me.
You have made the medical officer respondent.
Yes, my lord. So that, but my lord, it's the patient himself, he is not, the rule is that he is not given the copy of the report. A patient who is suspected to be suffering from
He's a performer.
schizophrenia. Yes, my lord.
The performer, not
Yes.
necessary.
So-
Strike out the name.
My lord, my lord, my lord.
He's a performer, not necessary.
My,
And in fact, he can appear on his behalf. This is not by name.
my lord, my lord, my lord,
So he will appear.
my lord, my lord.
You can appear.
We only want that, my lord, the psychoanalysis report, those 4 tests, it may be placed on record of this honorable court. Beyond that, we have nothing,
That is a different direction
My
for
lord.
which you have to file an IA.
my lord.
It's a
My lord,
different
my
thing.
lord.
So otherwise the service is complete. He can appear.
Lordship, in that view of the matter, let them serve a service copy, Lordship, so
Huh?
that I will intimate.
Oh, my lord, respond in that
You get
case.
a paper book. Paper book will contain everything. In fact, the appeal memo will also be there. So you get 2 paper books
My lord, my lord.
or 1. 1 will do. It's a jail appeal.
Yes, my lord.
Ah. You are an amicus?
I'm legal aid counsel, my lord.
Legal aid counsel.
Yes, my lord.
So then the payment has to be made. Why are you making the payment?
Usually,
Legal aid counsel.
we are reimbursed. Yes,
Okay, you'll be reimbursed.
yes, my lord, my lord.
Okay. Hmm.
In that case, my lord, then if the respondent number 2 may kindly be struck off, so that it will not remain in this order stage.
Okay, Alejo. You write it like this. Heard Mr. Santiago, the learned counsel appearing on behalf of the appellant. The learned legal aid counsel appearing on behalf of the appellant. Mr. V. Jimumi appears on behalf of the respondent number 1. This court had duly taken note of the order passed by this learned court, passed by this court on 10/12/2025. And inquired with Mr. Santiago, the legal aid counsel, as to why the respondent number 2's presence is required. The learned counsel submitted that the respondent number 2's presence is required for the purpose of calling for a particular document.
My lord.
Because we are of the opinion that the respondent number 2 would be we are of the opinion that for the purpose of adjudication of the present appeal, the presence of the respondent number 2 is not required.
My lord.
If any document is to be called for, there will be a requirement of filing of an appropriate application. And this court would have the jurisdiction to pass appropriate directions to the authorities for production if such application justifies so. Accordingly, we strike out the name of the respondent number 2 from the array of parties. We have also noticed that the paper book has been prepared. However, the paper book have not been distributed amongst the councils on account of non-payment of the amount of ₹3793, as would be apparent from the office note dated 25/5/2026. Mr. Santiago, the legal aid counsel, submitted that the payment would be made today through the treasury challan, and the same would be placed before the registry. We accordingly direct the instant appeal to be listed on 17th of June 2026 for the hearing.
My lord, if it can be listed on 10th or 24th, because the earlier matter was listed on 17th.
24th also we have listed. You have only 1 day. Ask the Chief Justice to have 2 days. I'm having it on 17th. The reason why.
My lord, my lord, my lord.
You see, 10th, okay, new judge comes, new judge goes. The 24th, most of the judges would not be interested except the persons coming here.
My lord,
Here
no.
also, you are having this coming holidays.
Then 17th, my lord, my
The
lord.
holiday season is coming, so 17th.
My lord is wise.
17th. First up, for listing, for hearing on 17th, subject to the deposit of the treasury challan by the legal aid counsel
My lord.
before the registry.
Much obliged.
The paper book be also, in the meantime, supplied to the respective councils by the registry.
For orders, item number 8.
What is this? No affidavit filed.
Not yet, Your Lordship. Records are here, Your Lordship.
Okay, what is your case?
My pleasure, Lordships. Lordships, the petitioner hearing is challenging the detention order dated 8 April 2026 and the approval order dated 16/4/2026. Primarily on the ground that nowhere in the detention order it is mentioned that I'm likely to be released on bail.
Why haven't you filed the affidavit, Mr. Longobar?
Your Lordship, apologies. I was short on time, Your Lordship. I received the record on Friday and due to some personal
You
difficulty,
file an affidavit.
Your Lordship.
We have it on 3rd.
Your Lordship.
Taking up for final disposal, you file the affidavit by Monday.
Okay.
Because of the fact that we have to give you an opportunity, but this will be the final opportunity pertaining to filing of the affidavit. To produce the records also on the day. And records also, because here his case is covered by our judgments.
Yes, ma'am.
He is not going to get a bail. He was only arrested on when?
30/03/2026.
Huh?
30/03/2026.
The
30th March.
30 March.
Yes, ma'am.
And you have been detained on 8 April.
Ma'am.
And the cases is under 16 and 18 of UPA. UPA, then do they get bail so easily? Unless you say that he is likely to get bail, file your affidavit.
Your Lordship.
It is noticed that no affidavit has been filed by either of the respondents. By the respondents. Mr. Nuguli, the learned
My lord,
counsel, learned CGC submits that he has received a scanned copy of the affidavit.
Yes, madam, duly notarized matter.
Copies thereof have been furnished to this court. So they say same are kept on record, subject which should be considered and are kept on record. However, the respondent, he further submits that in the meantime, the moment he receives the original affidavit in opposition, he may be given the liberty to file the same. Taking into account the above, list this matter on 3rd of February, 3rd of June 2026 for final disposal. Affidavit on behalf of the respondent state be filed on or before 1st of June. 1st of June 2026. On or before 2nd of June 2026. Mr. Longkumar, the learned counsel, appearing on behalf of the state respondents, is directed to produce the records on the next day. Mr. Nuguli, the learned CGC, is granted the liberty to file the original affidavit received from the central government upon receipt of the same.
Not typing this scan copy with the country. Except
You made 2 copies.
yes.
But you file in the meantime,
But
unless it is walking slowly and coming from Delhi.
For orders, item number 9.
What are these? Mr. Gauhati?
Donation of plaintiffs. Oh,
Lord, there is a delay of 162 days.
How much?
162. On please.
162.
Yes, there's a the 176 of 2005.
Mr. Longchan, are you objecting?
Yes, I filed my reply.
Your file?
Yes. I've given. Even after that, your lordship has given them ample opportunity, but additional affidavit also doesn't speak anything.
Lordship is my lordship will be in IA case 176 of 2025. Must by leadership says that delay caused due to the delivery of groceries can be controlled. Page 9 of Parliament.
I think on the last occasion, you were given an opportunity to file additional affidavits.
Additional affidavit for you. The day here also I said that it was little judgment. This is a judgment by her leadership lordship.
Mr. Yongamati,
Yes, my lord.
if we see the judgment, the court has not interfered with other aspects,
My lord.
only on the aspect of the discharge order.
Mm.
He have been reinstated and to be given the back wages. That is one aspect. The court has remanded the matter back to you.
Well,
Have you taken a decision in pursuance thereto?
no,
Why? Is there contempt application?
there is a contempt petition also pending. Lordship. There is a writ petition also pending. It's, same petition.
So why haven't you complied with this order? The order was passed. What was the order, impugn order? Let us see.
In the contempt petition, Lordship, I have not appeared. in it.
Petitioner has been reinstated in service forthwith with full back wages and all other service benefits. The matter is remanded back to the respondent authorities to re-decide on the question of necessity to discharge the petitioner under the provisions of 107 read with 108 of the Assam Rifles regulations, keeping in view the discussions made in this judgment.
Lordship, in the contempt petition, I am not the counsel.
Not on that. I'm not, you are a contempt. I'm not on that aspect. But my question is out here. Your grounds which you have submitted
Yes,
in your
yes,
application is insufficient.
Yes. It's very fact. In fact, Lordship.
I gave you an opportunity taking into account that whatever it is, unless you persuade us that you have a very strong case inclined.
Yes, Lordship.
You say, we have given you an opportunity. Now, recently, there are 2-3 judgments of the Supreme Court.
Hmm.
Isn't it, madam? One is, anybody has got those judgments?
Is Sir Ahmed Khan in Amarnath?
Recent judgments, wherein the Supreme Court went to the extent of saying that you have to also explain at the time why within the period of 30 days also you could not file. Very poorly drafted application. You should have given details. Madam.
The additional affidavit, there is nothing.
Yes, Lordship, basically because of administrative, interpersonal.
Because on the last
Okay.
occasion, I clearly remember because I was there, we told you at least to get some dates from which department it went on which date, but nothing is there.
In the state case, if the petition is not condoned, grave legal justice, but because there is a writ petition also pending. The contempt petition is also pending, which I'm not taking up, and in this present appeal. So my prayer is to let this appeal be condoned, this petition be condoned, and let the matter be discussed on merit. This dismissed on merit. Then there's a delay of 162 days on the Lordship.
162.
162 days.
Para your application in receipt. That in preferring the instant rate appeal, there is a delay of 162 days.
Yes, that's all.
From when? Up to what?
The instant application under Section 5 of the Indian Limitation Act has been filed, praying for condonation of delay of 162 days in filing the connected writ appeal arising out of WPC number 212 of 2022. So, heard learned counsel for the applicant, Mr. Gauhati. So also heard learned counsel, Mr. Inti Longcha, for the writ petitioner / respondent. So, by filing the instant application, the applicant has prayed for condonation of delay of 162 days in filing the connected writ appeal against the order dated, against the judgment and order dated 13/8/2025, passed in WPC 212 of 2022. Stop. Upon perusal of the application herein, we find that the reasons for the delay has been set out in the application at paragraph 4 and 5. Stop. At paragraph 4 of the application, it is stated that the instant writ appeal is filed with a delay of 162 days. And at paragraph 5 of the application, it is stated that there are good and substantial grounds taken in the writ appeal, and in all likelihood, they would succeed in the same, and that no injustice would be caused to the respondent / petitioner in the event the delay of 162 days is condoned. Stop. Besides the above statements, we find that there is nothing in the application showing the delay, showing the day-to-day delay, or at least the dates on which the process of communication / processing of files was taken from department to department. Stop. Upon finding that the reasons for the delay was insufficient, this court, right order dated 18/3/2026, had given an opportunity to the applicant to file an additional affidavit in order to fill up the gaps and to give sufficient cause for the delay. Stop. An additional affidavit has thereafter been filed by the applicant on 17/4/2026. Stop. No. When did you file your additional affidavit? On yes, 17/4/2026. In the additional affidavit which has been filed, the reasons for the delay has been set out at paragraph 5. Stop. In paragraph 5, the only reason which is stated is that government decisions are involved which requires multi-level processing and consultation, which may consume reasonable time. Stop. In this instant case, on receipt of the judgment and order dated 13/8/2025, which was examined at inter-branch levels and thereafter decided to file an appeal. Stop. Therefore, we find that even in the additional affidavit which has been filed by the applicant, no proper cause has been shown, and specifically no dates have been given as to when the file had been processed from table to table and from branch to branch. Stop. Para. You're relying on this.
Your IA 176.
Para. The learned counsel for the applicant has placed reliance on an order dated 3/3/2026 passed by a coordinate bench of this court in IA Civil 176 of 2025, wherein a delay of 485 days in filing the connected writ appeal by the Union of India was condoned. So, learned counsel for the applicant, Mr. Gauhati, submits that the instant case is squarely covered by the said order dated such and such, and prays that the instant application may be allowed. Fair enough. Upon perusal of the said order dated such and such, it is found that in that application, the delay has been explained by the applicants, and the delay has been explained sufficiently by the applicants, and the interdepartmental correspondence and approval had been shown. So therefore, the facts and circumstances of the said case are different from the instant application. Para. In view of the above discussion, we find that the applicants have not been able to show sufficient cause for the delay of 162 days in filing the writ appeal, and accordingly, the application is dismissed.
My lord, writ appeal arising yes. March applies.
For orders, item number 18.
So in the main appeal, I think both IAs closed. I think there was another IA.
The order passed
And
in.
then in the writ appeal, in view of the order passed in IAs and such, just
This eye is closed and the writ appeal also stands dismissed
dismissed.
in view of the delay being of dismissal of it.
For orders, item number 18.
Yes. May I please, Lordship? Lordship, this IA 112 is a delay,
How much?
227 days.
You've given good grounds.
And the appeal is preferred against judgment given by the Honorable Single Judge in WPC 108 of 2024. And the respondent is a sole respondent.
What is happening? Have you filed you see, you are having a lot of problem pertaining to there are two judgments. One is the Nisivi and there is another one.
Yes.
The other one went to the Supreme Court.
Nishimi also is Supreme Court.
Supreme Court Nisivi went in your favor.
Yes.
Other one went to the Supreme Court, wherein the Supreme Court you dismissed it by keeping the point of law open.
Withdrew. Not dismissed.
You withdrew. withdrew by keeping the point of law open. That is by the order passed by Justice Justice Robin Phukon.
Yes.
Isn't it?
Yes.
Justice Robin Phukon and I think Justice Budhi Abong. They have passed this order. And there was another order passed by me and this is Shyam, which have been held to be per inquiry in the second judgment.
Yeah, another one is 82 of 2026, I think. Your Lordship has passed one similar case. WBC 82 of 2026, which was disposed in the month of March. Is it a related one? But Your Lordship, in this matter, of course, there is a delay of 227 days. But here, the Honorable Single Judge, he just totally ignored the judgment given by the Honorable Supreme Court. So while ignoring a judgment by any Honorable Court, one has to focus on a different angle because any High Court or Supreme Court, when a judgment is passed, so there are so many angles has to be looked and they pass a judgment. So here in the present case, the Nishibi case is what petition was filed after 12 years. Here in the present case is 13 years. But here the Honorable Single Judge says that the husband of the deceased was on the advanced stage of the serial number. Whereas Nishibi case, the serial number was not mentioned. So it cannot be focused only on the seniority of the employee. That's not the only factor. When the Nishibi case was passed by the Honorable Supreme Court, we need to examine on what principle, on what object that the very case was disposed of. So it has to be looked into. And
You are
these
for
respondent.
You're filing an objection? No.
We will file the objection.
Why? It's an
We just
important
cannot
question to be looked into.
Accept notice on behalf of the respondent.
Anyways, let them file. Have you given good reasons or not? Let
We
us see
can
what
take
is
it up
your
next week.
reason. Why did you wake up so late?
Spell out your reasons. Paragraph 5.
Paragraph 5, 6, 7, 8, actually my delay. Lordship, admittedly here also aspected by this Honorable Court. Detail could not be, but I am ready to give the detailed sequence of the delay. Otherwise,
I think it's better if you file additional affidavit. Here also same thing.
yes.
Give some more details.
Definitely.
Or let us issue notice.
Lordship.
In reply, you give those.
Lordship.
Better. But give better details.
Lordship, I'll do that.
Issue notice making it returnable on 24th of June 2026. Mr. So-and-so accepts notice on behalf of the respondent. Extra copies of the instant application along with the copy of the writ appeal and the stay application be provided to Mr. So-and-so by tomorrow,
Lordship.
by Monday. By Friday.
By today, I can see most.
The respondent is granted the liberty to file the reply on or before 22nd of June 2026.
For hearing, item number 10.
Thank you, my lords. Lordship, here, the Deputy Solicitor General of India, Ranjit Kumar Dev Chowdhury, who is based in Gauhati, he is appearing, my lord, and he has requested if it can, this honorable court can kindly accommodate him on 17th.
Who is appearing?
Ranjit Kumar Dev Chowdhury, Deputy Solicitor General of India.
He is appearing for NIA.
Yes, my lord.
And what does he want?
He wants that the matter.
Oh, this matter came up before me earlier.
On 17th.
Last time.
Not this one, my lord. There is similar case which is pending, my lord. The other one was listed.
It came up before me and sister on 18/3/2026.
My lord, my lord.
This is against bail.
Yes, my lord, my lord.
Why? Or you don't want to open your mouth?
He is already out on bail, my lord, and no prejudice will be caused if.
But in view of that K. Najib's judgment,
My lord, my lord.
and more particularly in view of the recent judgment where it has been held in Arabi's judgment
My lord, my lord.
by the Supreme Court,
Yes,
when it says that in per matters also you are entitled to.
yes,
on
my
the
lord,
ground of
my lord,
delay.
my lord. In fact, my lord,
Although
on,
there is a reference now being made by another bench to a larger bench,
yes,
but the law is very clear that till that bench remains,
yes, my lord.
the till the judgment of Justice Nagaratna and Justice Ujjal Bhuya remains,
My lord.
in Arabia case, we are bound by that.
Yes, my lord.
Okay. So you are awaiting the outcome of the larger bench.
No, my lord. In fact, my lord, on 18th, also another decision was passed, my lord, saying on the same principle, my lord, that even in UAPA cases, PLST,
You are already on bail, na?
Yes, my lord, and bill, but I have not objected on several occasions to the adjournment. So, my lord, if the matter can be.
if a last
heard
chance
and
can kindly
disposed.
be provided, my lord.
I have the judgment of the recent. Yes,
Arabi.
but-
Arabi is it?
yes, yes.
Syed Iftikhar's judgment, I believe.
It's okay.
Bail was given on ground of delay, so the delay.
Yes,
on
my
time.
lord.
It's okay, you are there. He had the problem that Archdeep Chaudhary.
Yes, my lord.
Mr. Sentinel Learned Counsel, appearing on behalf of the appellant, submits that in the instant proceeding, the appellants have requested Mr. Archdeep Chaudhary, the learned Deputy Solicitor General of India,
My lord.
to appear in the matter. He therefore submits that he may be accommodated, the appellant may be accommodated today. So Mr. So-and-so, who appears on behalf of the private respondent, submits that the issue in the instant case is squarely covered by a recent judgment of the Supreme Court in the case of so-and-so versus so-and-so. Reported in.
It's a recent judgment arising out
My
of
lord, it's yet to be
SLP criminal
reported in
number
person.
10.
Reported in 2026 INSC 503. Itu naam ko sa libo ha, Syed Iftikhar Andrabi versus National Investigation Agency in Jammu. Also, taking into account that a request have been made, list this matter on 3rd. Next week. With this one.
On 17th, my lord, 17th June.
On 17th.
Yes, my lord.
On 17th of June 2026. You take this judgment.
Deeply obliged, my lord.
Keep it produced before the next page.
Lordship, item number 18. Item number 18. In course of our submission, I think principally Lordship also agreed to file a additional affidavit, but whether it's reflected in the order, allowing me to
You
file
want
it.
to file an additional affidavit?
Yes. To the satisfaction of the honorable court.
The petitioner, the appellant is, the applicant is further granted liberty to file an additional.
May I please, Your Lordship? Lordship, if I may be allowed to mention item number 10.
Item number?
10. Your Lordship, my senior is in this call, so if this matter may kindly be listed after a week.
We don't want to do it. Okay. 2024 matter. Why you are not doing it? 2 years have gone by. The council appearing on behalf of the petitioner seeks for an accommodation. When do you want it?
After a week.
This matter again on next Thursday. Not sure.
May I please, Your Lordship? I would to mention item number 9.
Lordship, I'm for respondent number 1.
Okay.
I'm for the state, Your Lordship.
Lordship, we have,
Now, who is appearing for the Union of India?
Lordship, we
You are
have,
appearing.
yes.
Now tell me why you have filed a writ?
We have already filed the, we have already sent the copy, we have already sent the copy of the reply to affidavit in opposition to the higher ministry. However, we're still waiting for the approved copy.
Now, why the appeal has been filed? A petition has been filed by Union of India. Challenging what?
Lordship, we are supposed to file the copy of reply to affidavit in
Yes,
opposition.
Mr. Counsel, who is appearing, or Mr. Sharif?
Yes, Lordship, they are challenging the order dated 17/9/14 passed by the Deputy Commissioner Dimapur. That is for fixing the rent.
This matter came up before me earlier.
Lordship, they were supposed to file the affidavit. The Lordship has fixed in the hearing matter list.
Yeah, 2021 matter. 5 years have gone by. And I think I took up the matter sometime in the month of December. Not December, August. Last August. Then, why should we grant an adjournment?
We've already filed, we have already sent our copy of reply to the higher ministry for approval. And
Is
we're
there
still
an
waiting.
interim order, Mr. Sharif?
No.
Okay.
No interim order. There was IA by order dated 4/4/22. An order has been passed with regard to filing of writ. There is no, but then our objection was with regard to delay in NHS. So as per order dated 4/4/22, it will be hard at the with the writ petition.
So we asked the Deputy Commissioner to go ahead and the respondent authorities to make the payment.
Yes, Lordship.
And keep the matter pending for whenever you feel like. Okay.
Not sure, I'm not conversant with the matter.
Then nobody appears, we dismiss for default the writ petition. You are not conversant, so we dismiss it for default.
Not sure, if I may be allowed, I'll call up my senior. The
Please call up
legal
your senior.
counsel.
Yes, call your senior.
Obliged.
For admission, item number 1.
Yes, what is this?
Lordship, this is landowner's case, my lord.
Landowner.
Yes, my lord.
Then?
Lordship, on coming to learn that there is to be a vacancy on the retirement of one Mayang Shilu at primary healthcare center under the medical department at Longsa village, my lord. Now, an application was made on the ground that I am a landowner. Now, my lord, the PHC Longsa is established on the land donated by 3 different clans. So I am from the Mungusangdang clan, my lord. So I have made an application before the Principal Director, Department of Health and Family Welfare, my lord. Now, Lordship, My application was also well supported, my lord, by a letter written by the landowners union recommending my name, my lord, which I have annexed in Annexure 7 of my petition.
These recommendations would not do any purpose
My lord,
unless
my-
it is
my-
being done by the deputy commissioner. Isn't it?
My lord. Now, my lord, another landowner, my lord, was appointed, the respondent number 7. I'm not saying that she is not a landowner, she is also a landowner. Now, when there were 2 or more applicants who are similarly situated, my case is that a selection process should have been conducted amongst us. A selection process should have been conducted amongst us, amongst the landowners, my lord. Now,
What do they say, the respondents?
the state respondents, they have come with an affidavit saying that, my lord, we have already been given appointments earlier
Where?
in annexures 1 to 6, my lord. So 2 each from the 3 clans have been accommodated earlier. And that in view of clause 3C of the notification, my lord, issued in 2018, which my lord is very well aware of. The petitioner cannot be accommodated.
Now, why is the respondent number 7?
Respondent number 7, my lord, we have affected service, my lord. An affidavit to that effect, lordship, has also been filed before this honorable court on 3rd of December 2025, my lord. By order dated 4/12/2025, this honorable court has held that service upon respondent number 7 is completed. My request at this stage, my lord, is that let the deputy commissioner conduct inquiry, and then if there are more than one applicant, then selection process may be initiated.
Your clan have received benefits.
Yes, my lord.
Both of you belong to the same clan.
Yes, my lord.
Then
But
you are the brother. Same clan.
it's a big clan, lordship.
So what? You're the brother. You should give way to your sister. Huh? They have done it properly.
No, my lord.
Why?
When there are more than 2 applicants, lordship,
I think Mr. Longkumar,
the selection process is usually
say that
conducted.
we set aside this and go for a normal process, taking into account that there are other landowners.
Yes.
you have categorically stated that there were 3 clans.
Yes.
Yes.
And all these 3 clans are have been duly have already availed benefits.
Yes.
Then the question of granting any benefit on land ownership does not arise.
Correct. Your
So
Lordship.
therefore, we direct that this post be advertised and sent given to everybody.
Your Lordship.
My lord.
Better off, no?
Yes, Your Lordship.
Because this will be again in violation to the AR 53/2018.
Your Lordship.
In fact, your statements made in paragraph number 7
Yes.
is contradictory to the statements made in paragraph number 6,
6.
isn't it?
Lordship.
It is categorically mentioned in the first paragraph, the second subparagraph. Sought for certain queries from so and he said that all the 3 clans have donated land
Yes.
and all have availed the benefit. So obviously it cannot be on land ownership basis.
Lordship.
So have a selection. Heard Mr. Sentianga, the learned counsel, appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent numbers 1 to 6. None has appeared on behalf of the respondent number 7, in spite of service having been met.
My lord, my lord. My lord, to that effect, order dated 4/12/2025 is on the court.
The present petition has been filed by the petitioner, being aggrieved by the approval granted by the government for appointment of the respondent number 7 to the post of grade 4 sweeper at Longsa PHC under CMO Mokuksong. By the communication dated 25/2025. This court have duly taken note of the affidavit which have been filed by the respondent numbers 1 to 6 through the respondent number through the Additional Secretary, Health and Family Welfare Department. From a perusal of the said affidavit, it is apparent that the Mongo Sangdang clan, Sempo clan, and Kumbor clan had donated lands for the construction of the Longsa PHC. The annexes 1 to 6 of the petition of the affidavit in opposition further shows that each of the clans have taken benefits of appointment on land ownership basis, not once but twice. At paragraph number 6 of the said affidavit in opposition, it is also made clear that in terms with the office memorandum dated 5/3/2018, appointment cannot be claimed on land ownership basis in perpetuity. This court is further of the opinion that as members of the 3 clans have already availed benefits under the policy of under the land ownership policy of land ownership policy, granting employment on land ownership policies of the state. Come on. The members of the 3 clans would not be further entitled to claim benefit on the basis of the office memorandum dated office memorandum or notification.
Notification.
The notification dated 5/3/2018. This This court, however, is surprised with the stand taken by the respondents at the official respondents at paragraph number 7, wherein, in spite of categorically mentioning that these three clans would not be entitled to benefits under the office notification dated 5/3/2018, then also proceeded to take the applications of the petitioner as well as the respondent number 7, who are both belonging to the same clan, for consideration for appointment on land ownership basis. And thereupon, it is further seen that thereupon, on the consideration between the petitioner and the respondent number 7, the government, the respondent's authorities have granted the approval for appointment of the respondent number 7 by the communication dated, impugned communication dated so and so, 25 আগতে কোৱা আছে।
25
It is the opinion of this court that taking into account that the policy of the government to grant employment on land ownership basis is an exception to Article 14 and 16 of the Constitution. First, under such circumstances, when the very policy of the government categorically mandates at the employment, the claim for appointment on land ownership basis cannot be made in perpetuity. And after the landowner retires or vacates the post, the vacancy has to be filled up through open advertisement in consonance with the existing government policy, giving equal opportunities to all applicants. The respondent authorities could not have considered the claim of the petitioner as well as the respondent number 7 on the basis of land ownership. Accordingly, this court is of the opinion that the impugned or communication dated so and so granting approval for appointment of the respondent number 7 is requires interference. The instant writ petition therefore stands disposed of with the following observations and directions.
My lord, if I may, my lord, during the pendency of the instant writ petition, the petitioner, he has turned 35 on 30 December last year, lordship. Now, the present petitioner may kindly be permitted to participate in any selection process, my lord.
No. That is, they will do, that is their local. Why should I give you? Merely because filing a writ petition, you don't get the benefit.
Because, lordship.
You have challenged land ownership basis.
Yes.
As on date, you filed the writ petition in 2025.
Yes, my lord.
Why did you file it in 2025?
Because
you were still claiming on land ownership basis. You see, Mr. Santianga, what you are doing out here is different. You have been claiming all along as a land ownership basis.
Yes, my lord.
and then not being successful, where your sister is getting the job out there, now you have come up out there and filed it. Now you want to say that you kindly excuse give me age relaxation. Why should I give you?
No, my lord, because the impugned approval letter was issued only on 20.
Next week, there is a division bench appeal.
Lordship, now again, Lordship.
No,
I have approached this on
Mr.
the-
Sentenga, no, Mr. Counsel.
Within the
Enough.
week, my lord.
No.
If, my
The
lord,
instant-
if
the
the state
resolution-
government advertisement and if I had not
The
participated,
impugned
Lordship.
communication dated 25/2025 issued by the Additional Secretary to the Government of Nagaland Health and Family Welfare Department, Nagaland, Kohima, whereby the government approval was granted for the appointment of the respondent number 7 as a grade 4 employee at Longsa PHC under CMO Mokuksong is set aside and quashed. Number 2, the post of grade 4 at Longsa PHC under CMO Mokuksong be filled up by way of an open advertisement as per the policy of the government of Nagaland. Full stop. The petitioner taking into account that when the petitioner submitted the instant writ petition, the petitioner was 34 years of age. That is well within the permissible age to apply in the advertisement, pursuant to any advertisement, and on account of the delay in disposal of the instant writ petition, the petitioner as on date have crossed the age of 35 years. The respondent authorities shall consider the petitioner's case for age relaxation if permissible under its extant laws.
You oblige, my lord.
For admission, item number 2.
Yes.
May I please, Lordship? Lordship, on the last occasion, 5/5/2026, one Miss A. Pradhan, on behalf of Mr. S. GTL, Learned Standing Counsel for the Income Tax Department, sought time for filing a affidavit in opposition. Till date, they have not filed, Lordship.
They filed the affidavit.
No, Lordship. In fact, the matter is fixed tomorrow. But due to the change, yes, due to change, it was today, so they might not be aware of it.
Just, no affidavit in opposition has been filed on behalf of the Income Tax Department, though time was sought for by the Standing Counsel of the Income Tax Department on 5/5/2026. Accordingly, list this matter on 27/2026. In the meantime, a final opportunity is granted to the Income Tax Department to bring on record its affidavit in opposition. First, the interim order passed earlier. Stand document Dilu next date to 27, 3rd of August. In the meantime, the interim order passed earlier shall continue till the next date. None appears also. Mr. So-and-so appears for a, none appears for the respondent for the Income Tax Department.
For admission, item number 3.
Lordship, similar order.
Similar.
File prosper.
This is a case of 1026, na?
Lordship.
I remember this case, 1026. Mr. B. Dave was doing the matter.
No,
Who was doing
people.
this matter?
People.
People.
People is.
He was doing the matter from video conferencing.
Yes, yes.
So,
For orders, item numbers 4 and 5.
why the matter has come up? Service is complete.
My lords, we have taken the steps through the registry.
Okay. Who appears for response number 11? What is response number 11?
Village Council. Merangong Village Council, my lord.
Huh?
The Village Council, my lord.
How can this order service be meted with Merangong Village Council, Merangong Village, Mokuksong, Nagaland? Can the service be affected like this?
Pardon, my lord, I
Can you affect the service with such a address without a PIN code, nothing?
my lord,
You stay in the same village.
for the sake of reputation, my lord, the implement of the Village Council was initiated by the state, and me being the petitioner, it is my prerogative to, of course, serve the notice.
No, my question is, do you stay in the same village?
Yes, my lord.
So therefore, you can affect by way of dusty.
That can be done. Yes, but
Both the petitions same. Why have two petitions?
one is for compensation for damages to residential property, and the other is for compensation to damages to agricultural products.
It is seen that pursuant to the order passed in IA Civil 48/2026, the respondent number 11 was made a party. It is in pursuance to an order dated in IA number order dated 33/2026. The respondent number 11 was impleaded, was arrayed as party to the accompanying writ petition in the instant writ petition. This court have duly taken note of that the service upon the respondent number 11 is yet to be completed, as would be apparent from the office note. It is also very pertinent to observe that the petitioner resides in the same village is the resident of the village wherein the respondent number 11 has its office. Considering that the matter that the service have not yet been meted out upon the respondent number 11, this court directs the petitioner to effect service upon the respondent number 11 by way of dusty routed through the registry of this court and file an affidavit of service on before the next date. List this matter again on 15th of July 2026. In the meantime, the petitioner shall take steps by way of the state to the petitioner should ensure that the service is meted out upon the respondent number 11 by way of dusty on or before 22nd of June 2026.
For orders, Item number 6.
Lordship, I have filed my reply this morning to the affidavit in opposition filed by the respondent number 8. My affidavit in reply to the affidavit in opposition filed by the state is under drafting, my lord. If my lord will kindly list this matter for admission hearing on Tuesday, my lord.
Why?
So that I'll be able to file my affidavit in reply by Friday, my lord, day after tomorrow.
You have filed the affidavit in reply.
Yes, my lord, to the affidavit in opposition filed by the respondent number 8, my lord.
1 to 5.
8, my lord.
Who is the 8?
Let's see the contractor.
One of the contractor also.
What are you asking for?
I'm praying for issuance of retained lordship because after the opening of technical bids, the private respondents, they were afforded an opportunity to make modifications in their bids, whereas the same opportunity was not given to us.
So have you been rejected?
Yes, my lord. And then
Lordship, opportunity was given for rectification, but the petitioner have not participated in the time period that was given.
we did not receive any intimation as such. Otherwise, we would have also made rectifications, my lord.
You are asking for an interim order?
Yes, my lord.
What an interim order?
Interim, yes.
We are not continuing with the interim order unless you file an indemnity bond.
My lord.
Tomorrow, if you lose the case,
My lord.
you will pay the entire escalation.
Lordship.
Lordship.
This was the work of 2025. 1 year escalation has happened.
Lordship.
So if the work is of 100 crores,
Lordship.
every year will be 10 crores.
Lordship,
Then this 10 crores should be paid by you.
Lordship.
Lordship, then interim may not be extended, my lord.
Huh?
Interim may not be extended in that case, lord.
Then?
And the matter can be fixed for admission.
Because this is the judgment of IVR Ronak International.
Yes, my lord. That 1999
makes it very clear
yes.
that in these type of matters, unless we can't take it up. What does respondent number 8 have to say anything? 8 or 9, whatever may be said, we are not concerned. We are only concerned with the state.
Yes.
Now, state have filed the affidavit in opposition.
Lordship.
You have filed the reply.
I have not filed reply. I'll be filing on Friday, lordship.
Why haven't you filed the reply?
I have filed the reply.
They filed the affidavit in opposition on 17/3/2026. Why haven't you filed your reply?
Lordship, there was some communication kept with the councils and I received only lately, lordship.
No, you can't receive it. You can't file without first having a copy, isn't it, Mr. Mosu? And you are always present in the court, so there cannot be a communication again. So nothing.
Lordship,
Lordship, main challenge is mine, the state.
We are not concerned with what respondent number
Yes,
7, 8,
my
8,
lord.
9,
Now-
6. We are not
now-
concerned.
Now the
You
money,
should have filed your reply against the affidavit in opposition filed by the respondent number 2, 3, 4, and 5.
Yes, my lord.
Why haven't you filed it?
now
On
Lordship,
Friday, lordship.
Lordship,
Since my lord will be here
now
Tuesday.
because of this litigation, 9 months has already lapsed.
He's going to pay.
And this is funding by the central ministry. So now earlier was annually it used to lapse.
Yes.
So now, and the main point is the allegation of the petitioner is that he was given time to rectify, but he did not did that.
Show me that document. We dismiss it right away. Why should I give him time? That is the only ground. That
Lordship,
we are
will find everything.
We are under 226 to see as to whether the actions are fair or unreasonable
My
or
lord,
so and so.
my lord.
They are yet to open the technical bid.
They have opened.
They have not opened.
Open.
They have opened. They have opened, lordship.
We have opened
And these three private respondents were selected. They have opened the technical bids.
No, they open later on.
Yes.
But prior to opening, you have been opportunity was given to everybody.
No, lordship. After opening, when there was shortfall in the documents, lordship, they were given opportunity. We were not given opportunity.
Let us see.
That is my case, lordship.
Mr. Imchen, kindly show your affidavit. You must have stated that.
Lordship, para 3 is important. Affidavit in opposition filed by the state.
Affidavit in
2, 3, 4, and 5.
Affidavit filed by respondent numbers 2, 3. Where is that affidavit?
You're correct, my lord.
These are the facts, nah? Project
No.
for performance of the work under so-and-so was sanctioned by the ministry amounting to 15 crores by
I've explained everything.
estimated civil cost of issues. The request for proposal was prepared following the so-and-so. As per section 2 India 1 under clause 12.200, the original documents of the bidders had to be submitted in the form of before. After the technical bid receipt online was opened on 36 in presence of the bidders. Total number were received online and the technical bids were evaluated as per the criteria laid down in month. And based on the documents placed before the committee examined the online and out of that only 3 bidders had submitted the complete document and as such recommended opening of the financial bids only who were read as so and so. As per the RPN, the technical evaluation is uploaded in the web portal of so and so. Was scheduled to be opened having 7 days time for objection if any bidder. No objection was received by the number was open. No objection was raised by the petitioner, then the petitioner was approached as not. Process of submission was in online, but under so and so the original must be submitted by the bidder. Only 3 out of 9 bidders have submitted the complete set of documents. Now, tell me, within these 7 days, which is being permitted, did you raise objection? Within the 7 days, which is permitted, because you see, if we see the notice inviting tender.
Lordship.
Page 35, not page 35. Where the schedule? Schedule will be there somewhere else.
Right?
Yeah. Page 31.
My lord.
Submit its financial and technical bids on so and so. Bids received online shall be open on 36. Bids through any other mode will not be. However, originals of the bid security, document fee, power of attorney, and joint bidding agreement, etc., shall be submitted physically by the bidder on or before so and so. Please note that the authority reserves the right to accept or reject. Now, pursuant thereto, which are the documents you are saying that they have given the opportunity to everybody to do that?
Lordship, which is why, Lordship, I may kindly be granted till Friday, my lord.
No, the matter is there. Let us see your writ petition. Forget about the other side. You say that the respondents have been granted an opportunity to fill up certain gaps which were there.
Yes,
So
lord.
on 36, 2025, the bid was opened.
Yes.
On that day, there is a period given out there. The bidding open will be on 36, 2025. Now, therefore, the financial bid would be open. Okay. What is the document on which you are saying that?
But the answer, answer 12, page 564, my lord.
500?
64,
564.
answer 12.
Okay. Minutes of the meeting of the bid. This is on 2nd of September.
Yes, lordship. This is
The
after
work
opening up
under
the
construction was sanctioned by the so-and-so as per the circular dated the year of so-and-so. The tender for the aforementioned work on amounting to so-and-so was invited by so-and-so. As per clause demand, the bidder must upload the scanned copy of the documentary in support of the onion deeds and so-and-so. The signer here must upload along with the bid in non-compliance of the above non-furnishing of the civil and so-and-so. None. Based on the documents filed before the event, the committee will examine the technical bit of the advocating. In case of 70 so-and-so. Your name is?
I am joint venture, my lord.
Huh?
I am the joint venture.
SN Enterprise.
Yes, my lord.
In the case of AI and JV with the so-and-so, the bidder had not stated that he had enclosed all the necessary formats and documents. However, upon perusal of the bid document, it was observed that most of the formats, that is Appendix 1A so-and-so, have not been provided by the bidder. The committee opined that the bid of so-and-so in JV with so-and-so and be considered as non-responsive. Then 6, 7, and 8 are who?
6 is lordship.
In the case of
yes.
bidder, this is
Respondent number 6 is
6.5.
vertex construction. 6.2.
Road safety auditor proposed by the ER does not have a road safety audit certificate from the appropriate approved government agency and hence does not have the required qualification. However, as per clause 9.1, a replacement for the road should be proposed by the bidder if the work is awarded to him. According the bid of is considered as provisionally responsive. It is the case of the roads proposed by the bidder has a diploma in an industrial fire and it's against the requirement of an auditor so-and-so. So-and-so the replacement of the years. So this is the replacement of the roads safety auditor.
Yes, lordship.
Yeah, should be proposed to bid by the bidder if the work is awarded to him. So they say that it can be given. This is the only thing. And vertex was, however, the committee observed that the bidder has submitted all the required documents and in order, and it was opined that the bid of vertex may be considered responsive. Now, what do you have to say against vertex?
Lordship, usually what happens is at least 3 bids must be considered to be responsive. Only then, lordship, retender is not issued. My lord.
What?
If less than 3 bidders are held to be by the technical committee to be non-responsive, my lord, then normally, ordinarily, fresh tender process is issued.
No, now you see, you have not submitted Appendix 1A, Appendix 2, Appendix 3, Appendix 4.
No, lordship, we have submitted, lordship. We have submitted actually. We have submitted, which is why, my lord, we have annexed all those submitted documents, which is why the petition is so thick, lordship. Whatever we have submitted, we have placed on record before this honorable court.
What is it? Let's see Appendix 1A.
Which is why, my lord, I may kindly be.
No, not necessary. I'm not looking into the affidavit. I'm looking from your case.
Yes, my lord.
In this type of matters, Mr. Sanjay, in the morning, evening, that is what I do in Gauhati High Court principal seat. So therefore, I don't even need their response to the effect. I may ask them to produce the records. That's all, nothing more than that.
Lordship.
That is, man, let's show me where. Where is your appendix? Appendix 1A is what? It will be there in the instruction to the bidders. Appendix is qualification information strictly as per the formats given in Appendix 1A of Section 3. Appendix 1A of Section 3. 1A of Section 3. Yeah. Details of the bidders. Where is this document you have given? Page 72, the similar document.
My lord, which page?
What is this document? Where have you given this? Page 72 in your bid. Here it is. Yes, Mr. Mohamson, while you were saying that Appendix 1A has not been given. How many members are there in the joint venture?
Two, my lord.
SN Enterprise and Southeast.
Yes, my lord.
Yeah.
Petitioners 2 and 3.
Where is your statement that you have given all these documents in your petition? Where is it?
Lordship,
Where is it you submitted that all the documents have been given? Where is your statement?
it is not stated, Lordship.
Well,
It is only stated that,
so
Lordship.
therefore your rejection,
Yes, Lordship.
which is being made, you are an invalid bidder.
No,
At the
my lord.
cost of it, yes.
I have placed the entire records.
No, I'm not going to look into it without the statement that you have submitted all these documents. Now kindly see, anybody has the Ronak judgment, paragraph 27, if I am not wrong. It categorically says that the instance of an invalid bidder, why should we entertain this type of petition? We dismiss it right away with cost of the amount of escalation.
Lordship, the records I have placed before this honorable court.
Why should I look into it?
Lordship.
Mr. Sintianga, first and foremost, it was their requirement to say that the minutes of the meeting is bad because they have not taken into consideration that these were the documents which have been placed.
Yes, my lord.
The mention by which it has been rejected.
My lord.
You are on the basis that, look here, I also failed, they also failed.
Yes, my lord.
So therefore, when they fail, They have been given an opportunity,
Yes.
why not me?
Yes, my
Meaning,
lord.
right? Isn't it your very case out there that you did not submit?
No, my lord, I have
Huh?
already
No.
placed, I have placed
No,
on.
no, my lord, this is basis.
I have placed on record, my lord. My annexure 1, annexure 2 are all before this honorable
What
court,
do
my
you
lord.
say, madam?
Are all before this honorable court.
Yes, that look here, madam has been allowed to, madam's clients have been allowed to submit. I have not been allowed to submit. If you were submitted, then why is the necessity for you to submit?
Exactly.
More particularly in paragraph number days of your writ petition, you categorically mentions that this is a new contract, paragraph number 5, that all line participants obviously
Yes,
will
my lord,
pay.
my lord. My
So
lord.
therefore, you by your own self-admission say that this is it.
No, my lord.
So therefore, if you are an invalid bidder,
Lordship.
you see,
Now
here-
all of us in there are in the same boat.
no, vertex is not.
Lordship.
You see, there is a difference.
Then, Lordship, then
vertex,
the opportunity that have been awarded
no, the
to
question would be different.
7 and 8.
6, 7, and 8. Now, let us assume the question of they are asking for this some radio document or something. What the radio auditor's document
Yes,
was this. Now, the authority, if you see the judgment of FCONS,
Yeah.
you have FCONS? Yes, give it to him. Yes, read paragraph 15.
Yes, Lordship.
Paragraph 15. You have not said nothing. Forget about the affidavit. I'm not looking into that. Paragraph 15.
Yes, Lordship.
Miss Santam, you have got the galaxy?
Lordship.
Yeah, see? She has everything. So
Lordship.
now we dismiss.
Now, Lordship, I have only one thing, Lordship. If I may be,
Please.
in, my lord, in 2024, 10 SCC 273, my lord. This is Pansita Construction Private Limited.
Huh?
Pansita Construction Private Limited, my lord, versus Bharat Cooking Coal Limited, Lordship.
What does it say?
It says that, Lordship, after the here similar case happened after the opening of the technical pits, one party was allowed to make rectifications, whereas the other party were not allowed to make rectifications. Now that party which was allowed to make rectifications, that party was selected, that contractor was selected. So the Supreme Court said that no, it should not have been done. Once technical pits are opened, once it is open, rectifications cannot be allowed to be made.
You, first of all, at your instance, would categorically being mentioned as you did not submit these 4, 5 documents, which includes the most pertinent document of Appendix 1A. Although it appears that from this document it is there.
Yes,
but the fact remains that how did you have this document? This document has to be submitted online.
Yes, Lordship.
Where is your certificate?
Lordship, I will bring all those on record,
Not
Lordship.
required. We dismiss it right away. Hello, Mr.
Lordship, now, Lordship.
We dismiss.
Lordship.
No, sorry.
Now,
And why do you say that opportunity was given to him also?
It was not given. It was never given.
No,
Lordship.
why are you saying that opportunity was given to him?
I think I've given to his juniors. He might be missing out.
Which one? No, my question is, why do you say, initially what do you, both of you were saying, that look here, we have given him the opportunity, he did not avail it. Where is that opportunity being given? Where is the document? Because your affidavit does not say a single word on that.
My lord, please see para 6 of my state counter.
Your counter.
Para 6 of the state counter. Seven days time was given for objections, Your Lordship.
At least, Lordship, I want to bring my reply on record.
Not
Lordship.
necessary.
Lordship.
We cannot state,
May I read your lordship?
yes, para 6.
Para 6, that with regard to the statements made in paragraph 6, 7, 8, and 9 of the writ petition, the answering tribunal, while reiterating and reaffirming the statement made in the preceding paragraph, simply state that the petitioner has failed to submit the requested documents during the time of submitting the tendered documents. As such, the bid evaluation committee has rightly rejected the bid of the petitioner as non-responsive, and thereafter, technical evaluation was uploaded in the web portal on 16/9/2025, and the financial bid was scheduled to be open on
No, this is-
23/9,
No, Mr.
giving 7 days time for objection.
Mr. Imchen, this is not what has been conveyed to this court earlier, that you have given him also an opportunity. In fact, there is no other opportunity given to anybody. You only say that if he is tomorrow selected, those persons are selected, both more particularly 7 and 8. 6 is otherwise qualified.
Lordship.
As regards 7 and 8, if those are the persons concerned who have otherwise, if they become responsive, they are held to be provisionally responsive. That means they are to submit, if they are granted the contract, this particular thing.
Correct.
So you have done it in this manner, which may not be right in qua the 7 and 8. But at the other hand, as regards 6, there is nothing out there. So at the instance of a bidder who is not qualified, and he has not challenged that aspect that he was qualified without a single statement. On the other hand, paragraph 5 of his affidavit says that all 9 bidders are new, so they would obviously fail. So therefore, his petition has to be dismissed. So that is what all this is. Okay. We dismiss it.
Lordship, I want to bring my reply on record.
Not
Lordship.
necessary.
After
But
that-
you do one thing, when you file your writ appeal, bring those aspects and say, this court did not grant.
Lordship, I have no such intention, but Lordship.
Mr. Santiyanga, enough. Heard Mr. Santiyanga, the learned counsel appearing on behalf of the petitioner.
Lordship, time is running out for the state. Time is running out for the state.
You'll get the order in done
It
and
is-
dusted. Mr. Imchen, you'll get the order done and dusted by 3:15. Just take your seat. Heard Mr. Santiyanga, the learned counsel appearing on behalf of the petitioner. Petitioners. Mr. You are appealing for Union of India? Union?
No, he's my private union.
Who is your union? No.
Union,
Get hold of a union council, he may be benefited by putting a bill.
union back.
Okay, we put Mr. Nugli's name. Okay, so and so appears on behalf of the respondent number 1. Mr. Moa Chen appears on behalf of the respondent number 225. Who appears for 6? Okay. 7.
Worship, I have instruction to appear for respondent number 7.
Ms. So and so appears for respondent number 7. So and so appears on behalf of the respondent number 8. None appears on behalf of the respondent number 6 on call. The present petition has been filed by the petitioner, being aggrieved by the decision taken on 2/9/2025 by the bid evaluation committee, whereby the petitioner bid on one hand was held to be technically non-responsive, and the bid of the respondent numbers 6, 7, and 8 have to be held to be responsive. First, at the outset, it is relevant to take note of the first, The brief facts which led to the filing of the present writ petition are that the Chief Engineer PWD NH Nagaland had issued a notice inviting tender, thereby inviting inviting bids from experienced firms or big organization for operation and maintenance works and activities relating to the performance-based maintenance contract bracket PBMC bracket close work on NH02 bracket old NH61 bracket close from KM 125.000 to KM 135.000 bracket length is equals to 10.00 km bracket close under NH division dash Roman 2 Mokokchung in the state of Nagaland. In the said notice inviting tender, more particularly, it's at section 1. It was categorically mentioned that the bidder must submit its financial bid and technical bid by online in https://eprocure.gov.in/eprocure/app on or before the bid due date, that is 23/6/2025 bracket up to 1200 hours server time bracket close. It is also mentioned that bids received online shall be opened on 30/6/2025 at 1300 hours server time. Further to that, at section number 1, it is mentioned that the originals of the bid security, document fee, power of attorney, and joint bidding agreement, etc., shall be submitted physically by the bidder on or before 30/6/2025 at 1200 hours IST. Full. The said tender contained various terms and conditions. Section 2 of the said notice inviting tender related to is in respect to the instruction to the bidders and the appendix. Full stop. The said is hereinafter for short referred to as the ITB. Full stop. From a perusal of the said document, more particular a perusal of the ITB, it is seen that clause 3 stipulates who are the eligible bidders. And what are the necessary documents which are required to be filed? Along with the bid so submitted. Clause 4 relates to qualification of bidders. The qualification of the bidders had to be given in Appendix 1A, which is specifically, the format of which have been specifically provided at Section 3 of the notice inviting tender. The petitioner, along with 8 other bidders, submitted the bids. First, the technical bids were opened on 36/2025. First, in presence of all the bidders, including the petitioners. Admittedly, there was no objection filed by the petitioners. Before the authority concerned in respect to the deficiency in the documents of other bidders.
Lordship, I have not admitted that, Lordship. They have stated that in their affidavit in opposition. I am yet to file my reply, Lordship. I have no instructions whether within those 7 days objections have been filed or not, my Lord.
Did you file that application?
I have no
Did you
instructions.
file any objection?
I have no instructions, my Lord.
There is nothing on record to show that a petitioner have raised any deficiency as regards the deficiency, had raised any objection to the deficiency of the documents of the other bidders pursuant to the opening of the technical bid.
My Lord.
The records further reveal that the technical bids of the 9 bidders were evaluated on 2/9/2025 by a bid evaluation by the technical evaluation committee. The minutes of the meeting of the bid evaluation committee is at Annexure 12 to the writ petition. From a perusal of clause 6 of the said minutes of the meeting, it is seen that insofar as the petitioner is concerned, it was categorically mentioned at clause 6.3 that the petitioners did not state that the petitioners enclosed all necessary formats and documents. It was also found upon perusal of the tender documents that most of the formats, which Appendix 1A, capital A, Appendix Roman 2, Annexure Roman 2, Annexure Roman 3, Annexure Roman 4 have not been provided by the petitioner. It was under such circumstances the bid evaluation committee was of the opinion that the bid of the petitioners were not responsive. Insofar as the respondent number 6 is concerned, at clause 2 of the 6.2 of the minutes of the meeting, it was mentioned that the respondent number 6 had provided though have not provided the undertaking as mentioned in clause 12.2H of the RFP. But the committee observed that the bidder had submitted all required documents in order, and it opined that the bid of the respondent number 6 as responsive. Insofar as the bid of the respondent number 7 is concerned, at clause 6.5 it was observed that that a road safety auditor proposed by the bidder did not have a road safety audit certificate from the appropriate approved government's agency and hence did not have the required qualification. However, as per clause 9.1 of the contract agreement, a replacement of the road safety auditor should be proposed by the bidder if the work is awarded to him. And in such circumstances, it was observed that the respondent number 7 was provisionally responsive. Same was the case as regards the respondent number 8, which is considered in terms with clause 6.7 of the minutes dated 2/9/2025. The said minutes were uploaded on 23/9/2025. At this stage, this court finds it very pertinent to take note of clause 23.5 of section 2 of the ITB, which categorically mentions that the employer shall inform the bidders about the result of the technical evaluation by uploading in the web portal, giving 7 days time for objection, if any, from the bidders. It further stipulates that the employer shall finalize the evaluation of the technical bids after due consideration of objections received and intimate the bidders whose technical bids are found responsive of the date, time, and place of opening of the financial bids. It is also very pertinent to take note of clause 23.1 of the ITB, which stipulates that after notifying the technical bid the substantially responsive bidders would be further notified about the opening of the financial bid. First, the petitioner have not placed on record any document to show that the petitioner raised any objection as regards the technical evaluation, whereby the petitioner was held to be technically non-responsive, whereas as regards the respondent number 6, 7, and 8, they have been held to be technically responsive. First, the petitioner instead approached this court by filing the writ petition on 26/9/2025, which is 3 days post. 3 days, na? When did you open the financial bid? 23/9.
23/9/25.
Which is 3 days post the opening of the financial bids, which was notified on opening of the financial bids. The instant upon filing of the present petition, this court, by an order dated 26/9/2025, issued notice and further state the bid evaluation, minutes of the bid evaluation committee dated 2/9/2025, as well as the entire tender process till the next returnable date. The records reveal that the respondents, the interim order thereupon have been continued from time to time. It is further relevant to take note of that the respondent state have filed the affidavit in opposition on 17/3/2026. Copy thereof was duly furnished to the petitioner. In the said affidavit in opposition, what has been mentioned? Affidavit in opposition filed by respondents. Number 2, 3, 4, and 5. The various the facts already narrated herein above have been reiterated, have been mentioned, and as such, for the sake of brevity, this court would not like to repeat the same. It was further mentioned that out of the 9 bidders, only 3 bidders had submitted the complete set of documents. As such, the committee recommended opening of the financial bids of only those 3 bidders who have been erased as respondent number 6, 7, and 8. It was also mentioned that the petitioner did not submit most of the formats, that is Appendix 1A, Annexure Roman 2, bracket technical capacity of the bidder, bracket close, Annexure Roman 3, financial capacity of the bidder, comma, Annexure Roman 4, details of the eligible projects. And as such, the petitioner's bid was held to be technically non-responsive. Insofar as the respondent number 6 is concerned, it was mentioned that the technical evaluation committee found that the respondent number 6 have submitted all the necessary documents. It was, however, mentioned that though an undertaking was not uploaded in the bid, from the person having the power of attorney as per clause 12.2H of the RFP. However, the said document was physically submitted in terms with clause 12.2 of the RPF. Pusto. However, the original of the said undertaking was physically submitted as per the mandate of within the time permitted on 30/6/2025 at 1200 hours. Insofar as the respondent number 7 and 8, it was observed, it was mentioned that the technical evaluation committee deliberated the bid submitted by them and found both the parties have submitted a complete bid. However, it was observed that the road safety auditor proposed by both the bidder did not have the requisite qualification. So, taking into account clause 9.1 of the contract document, which required the contractor to employ the technical personnel named in the contract data or technical persons approved by the engineer, it was observed by the technical evaluation committee that a replacement of the road safety auditor should be proposed by the bidder if the work is awarded to either of them and consider the bid of the private respondents number 7 and 8 as provisionally responsive. No affidavit in reply had been filed by the respondents by the petitioner. In addition to that, the affidavits have also been filed by the respondent number 7 and 8. You have filed?
We're yet to file.
Okay, you have not filed. Respondent number 8, you have filed. Filed by the respondent number 8. So, taking into account the above, taking into in the backdrop of the aforementioned pleadings, this court now finds it relevant to take note of the case projected by the petitioner. Mr. Sentienga, the learned counsel appearing on behalf of the petitioner, had submitted that the petitioner have not been treated fairly, which is the mandate of Article 14 of the Constitution. Inasmuch as the respondent number 6, 7, and 8 have been provided opportunities to submit certain documents at a later stage, whereas the petitioner have not been provided such. He therefore submitted that if there is a discriminatory treatment meted out by the tendering authority, the impugned actions would be in violation of the equality clause mandated under Article 14 of the Constitution, and this court would exercise the jurisdiction under, ought to exercise the jurisdiction under Article 2 to 6 of the Constitution. In that regard, he has referred to the judgment of the Supreme Court in the case of Banshidhar Construction Private Limited versus Bharat Coking Coal Limited and others, reported in 2024 10 SCC 273. And specifically referred to paragraph number
22, my lord. 22.
22. First. Mr. Moin Chen, the learned senior government senior. The senior government advocate appearing on behalf of the respondent number 225 submitted that the instant writ petition cannot be maintained at the instance of an ineligible bidder. Inasmuch as unless and until the petitioner can say that he had the technical qualifications, unless and until the petitioner questions his rejection of the technical bid, he cannot question the evaluation proceedings, the technical evaluation proceedings dated 2/9/2024, by which the respondent number 6, 7, and 8 have been held to be technically responsive. The senior government advocate, further referring to paragraph number 5 of the writ petition, categorically submitted that it is the self-admission of the petitioner that the petitioner did not submit all the documents. There is not a single statement in the writ petition that the petitioners had submitted those documents, and in spite of that, the respondents have rejected the petitioner's bid. The only case of the petitioner as set out is that the petitioner ought to have been granted an additional opportunity to submit those documents, inasmuch as such opportunity was granted to the respondent number 6, 7, and 8. The learned counsel, appearing on behalf of the learned senior government advocate, further submitted that the case of the respondent number 6, 7, and 8 are completely different, inasmuch as the undertaking which was to be given by the power of attorney holder in terms with clause 12.2 of the ITB was duly though not submitted online, but duly submitted on or before. The original physical copy was duly submitted on or before 1200 hours on 30/6/2025, which is the mandate of the notice inviting tender. The learned counsel further submitted that in terms with clause 9.1, there was a requirement of a radio auditor. What is the name? Radio safety auditor, road safety auditor. Road safety auditor. Full stop. The learned counsel submits that in terms with clause 9.1 of the ITB, it would show that even if the bidder had given a road safety auditor, the name of the road safety auditor, that the same can be very well changed and by the engineer in chief. The appointment of the road safety auditor was subject to the approval of the engineer, as would be seen from clause 9.1. He therefore submitted that merely because of the fact that the road safety auditor did not have a qualification, did not meet the technical qualification, did not meet the qualification comma. The bid of the respondents, bid of the said respondents were not rejected in as much as the bids, in as much as the road safety auditor, appointment of the road safety auditor would only come if, as and when the bidder is being granted the contract. The Learned Council further submitted, senior government advocate further submitted, that this is the understanding of the tendering authority. The understanding under no circumstances can be said to be perverse or mala fide. And under such circumstances, this court may not like to interfere, taking into account the observations of the Supreme Court at paragraph number 15 of the judgment in the case of F-Cons versus so-and-so, reported in 2016, 15 SCC, page 5.
2016, 16.
15 SCC.
SCC 818.
This is what?
F-Con.
F-Cons? I don't think so. No. Okay, 2016. 2016, 16 SCC, 818. This. Okay. Ms. Aprila Singh, Santam, the Learned Council appearing on behalf of the respondent number 8, and Ms. So-and-so, who appears on behalf of the respondent number 7, supported the submissions of Mr. Mwa Imchin, the learned additional, a learned senior government advocate. In the backdrop of the above pleadings, as well as the respective submissions made by the learned counsels appearing on behalf of the parties, the question arises before this court as to whether this court should exercise the powers of judicial review under Article 2 to 6 of the Constitution. First, this court have duly perused the writ petition. A perusal of the writ petition nowhere mentions that the petitioner questions the rejection of the petitioner's technical bid on the ground that the petitioner had duly submitted those documents which are Appendix 1A, Annexure Roman 2, Annexure Roman 3, and Annexure Roman 4, which are the reason for holding the petitioner as technically non-responsive. Rather, at paragraph number 5 of the writ petition, the petitioner states, the petitioners have categorically stated that as the work in question is of such nature, all the 9 bidders, including the petitioners, have failed to submit all the documents. In that view of the matter, the petitioner's bid, in that view of the matter, the rejection of the petitioner's bid on the ground that the petitioner is technically non-responsive, having not been questioned before this court, the petitioner is an ineligible bidder. Now the question arises as to whether the petitioner have been unfairly treated, in as much as it is the case of the petitioner that the petitioner have not been afforded an opportunity to provide those documents, whereas the respondent number 6, 7, and 8 have been provided such opportunity. First of all, this court finds it relevant to take note of clause 12.2 of the ITB. which stipulates categorically which are the original documents which are to be submitted in the physical form on or before 30/6/2025 at 1200 hours. The documents which are to be submitted includes that an undertaking from the person having the power of attorney referred to in subclause A of clause 12.2 that they agree and abide by the bid documents uploaded by the Chief Engineer PWD NH Nagaland and amended, uploaded, if any. It is the specific stand of the said document, stand of the respondents in the affidavit, as well as it is seen from the minutes of the meeting held on 2/9/2025 that the respondent number 6 had duly submitted the physical document prior to 1200 hours on 30/6/2024. 25, na? 25. First, under such circumstances, it cannot be said that the respondent number 6 was technically not responsive. Clause 9.1 of which document? Okay. Insofar as the respondent number 7 and 8 are concerned, it is seen from the technical evaluation being carried out by the bid evaluation committee that the road safety auditor did not have the qualification. And therefore, the bid evaluation committee observed taking into account clause 9.1 of the general conditions of the contract, that the bidder, if held to be successful and the contract being granted, would be bound to employ the technical person who will be approved by the engineer. And therefore, the said did not constitute a ground for rejecting the bids of the respondent number 7 and 8. Under such circumstances, it is the opinion of this court that this is not a case where options have been given to the respondent number 6, 7, and 8, to respondent number 7 and 8, 6, 7, and 8, to submit any documents at a later point of time. In the case of the respondent number 6, it was observed that the document was already there. As regards the respondent number 7 and 8, it mentioned that would only arise if the contract is being granted. Considering the above, this court is of the opinion that the question of fairness, which is being questioned, the aspect of fairness which have been questioned by the petitioner, have no merits to stand. This court also takes note of the judgments of the Supreme Court in the case of Bansida Construction Private Limited, Supra, to which the learned counsel appearing on behalf of the petitioner have referred to, and more particularly to paragraph number 22. The said judgment, in the opinion of this court, is completely misplaced, taking into account that in the said case, the appellant was rejected by the respondents on 6/5/2024 on the ground it did not comply with clause 10 of the NIT. Whereas the respondent number 8 therein was held to be technically compliant without having complied clause 10 of the NIT. There's a substantial difference in the said aspect with the facts of the instant case. Considering the above, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed with a cost of rupees 1 lakh. Interim orders, if any, it stands vacated.
Lordship, the post mechanics have been imposed. Lordship.
How much? 55.
No cost, my lord.
No, this is a cost.
No,
Tender is a cost. You have to, what do you do? Cost.
No, my lord.
One has to give. No means what? File appeal on that. This is a good ground for filing appeal, 1 lakh cost.
No, my lord.
Yes. Okay.
Otherwise, Lordship, deeply obliged, Lordship.
Obliged, Lordship.
Langkah batang, langkah balik.
May it please, my lordship.
Yes.
The private respondents have not met here. It's almost 2 months.
What is the application for?
Lordship?
What is the application?
Yes, lordship.
You got to stay.
Yes, lordship. In both the main writ petition as well as in the IA. We had to, after the stay, we had to file an IA because even after this honorable court stayed it, the DB's court, Sinheboto, they started issuing summon to proceed with the case. That's why we approached this honorable court in
Now
IA.
have they stopped?
Yes, we submitted. And
This court has
since
taken note of. There
My
is
lord.
no-
May it please, I want to make a specific mention on 28/4/2026 at Vera 5,
Huh?
in the order Vera 5.
Of this order.
Yes, ma'am. Requisite extra copies of the writ petition be served on Mr. L.D. Sangta, learned additional AG for the state in the course of the day. I'm yet to receive the extra copies.
Now, did you get the copies of the writ petition earlier?
It should be IA.
for IA,
It should be IA,
Aye.
but mention isn't in about R. But I'm yet to receive
copies, my lord.
So that is.
The Supreme Court has said that orders and judgments should not be taken as an elusive theory, that it is not a statute, so obviously there might be mistakes. We are humans.
Yes.
Anyway, service is not complete, so we have it on some other day, asking them to give service. Who is the respondent number 4 and 5?
4 and 5 are the ones who have filed the appeal before the deputy commissioner.
Okay. Then why don't you affect it by way of the state?
Yes, I'm going to pray for that, Lordship.
The record reveals that the service upon both the respondent number 4 and 5 is not complete in the writ petition as well as in the interlocutory proceedings. It is the opinion of this court that service upon the respondent number 4 and 5 having not been complete, the present proceedings cannot be proceeded with, though there is an interim order. Cannot be proceeded with. Considering the above, this court directs the petitioner to effect service by way of dusty upon the respondent number 4 and 5, routed through the registry of this court, and file an affidavit of service on or before the next date. List this matter again on 23rd of July 2026. Service be meted out by way of dusty by the petitioner on or before 24th of June 2026.
My lord, extra copies for service of notice upon the state respondent.
You have not
1, 2,
given?
3.
No, I have given. I have the writ petition. I have already served.
IA.
IA, only IA. You mean to say?
I think you give it, don't it? It looks nice in the records.
I beg your pardon, Lordship. I shall give even my copy today.
Give the extra
Three copies. 1, 2, and 3.
Okay.
I'm not putting it.
Lordship, interim order dated 2/4/2026 in the main writ petition may be continued, as well as in the IA. IA is on 28/4/2026.
The interim orders passed in the writ petition, as well as also in the interlocutory application, shall continue till the next date.
Highly obliged, Lordship.
For orders, item number 8.
Lordship, in this connection, Lordship, I filed one IA because there has been inadvertently, there's been a clerical mistake in the course title. I filed one IA.
What happened?
Lordship, the father's name and the address has been mistakenly, the father's name and the address has been mistaken.
Of both the petitioner.
Lordship,
One petitioner doesn't have a father or has a father. Whose father is their mistake?
the one, the which I have stated, the one should be number 2 and 2 should be number 1.
Anyways, the counsel appearing on behalf of the petitioner has submitted that he has filed an interlocutory application seeking certain
It has been numbered 116.
seeking certain corrections in the course title. To list this matter again on Monday along with the said interlocutory application.
Lordship. And I believe the notice upon the respondent number 4 is awaited.
We'll look into it, yes, on the next day. If you were to show it, I would have, otherwise you have filed an interlocutory, otherwise I would have asked you to correct it only. So anyways, we'll have it on.
I've already filed this.
For hearing, item number 9.
Yes, what do you have to say?
My lord,
The whole matter.
I've received
Mr. Counsel,
this
what is
affidavit
going
in
on?
opposition
I'll pass some
very
order.
lately.
Seeing
And I-
that an affidavit has been filed by the respondent here, the affidavit thereupon has been filed, and the petition is admitted, leaves the matter for hearing on 21. Okay, now
Now, my lord, I have this thing send this thing counter affidavit to the ministry. So the ministry is yet to make the reply. So
What counter
until-
affidavit?
Uh,
Affidavit in reply
yes,
to the affidavit in opposition.
yes, of the state government. Respondent
When
number
did you
three.
send it? When did they file the affidavit?
My lord, that was last year. But by junior, they have given-
23, not last year. 3 years back.
No, my lord. That was
Not
last year.
last year.
Yes.
No, 22.
It was, yeah, it was this thing. filed in 2021.
25, 2023.
Yes.
You have crossed that.
No, not 2023. I have received this affidavit in opposition on dated 12, on 8/12/2025. State respondent. And one of my
Isn't
junior,
it required to file the affidavit without, how an affidavit has been filed without giving copy to the other side? It is not possible. It has been received by, yes, it has been received by one Akiri Susi. Who is he?
yes. And then he has given me this copy.
Who is Akhiru Susi?
Akhiru is my junior.
So he has received it on
Yes, he has
25.
received it. He has kept it in the file. He has never informed me. I came to know
that you cannot make this.
Not my lord. This is in respect of respondent number 3, the state respondent.
Then
in respect to respondent number 1, I've already received it. But in
this is an
respect to
affidavit
respondent
filed by
number 3,
respondent number 1. This is an affidavit filed by respondent number 1 where
Yes.
the junior has received it. on-
yes, respondent number 1, I've received it. Respondent number 3, I've received it only last year.
There is no affidavit of the respondent number 3 here.
Yeah, may I please, Your Lordship?
Ah.
Your Lordship, I have already filed on the November 2025. However, Your Lordship, the meantime, I have already served the copy to the petitioner. However, there was some correction. The registry rejected it and I have filed it again, Your Lordship. So it will be,
So your affidavit is still not on record.
Your Lordship, there's some correction, Your Lordship. The registry rejected it, Your Lordship. That's why on 2-3 occasions, we have made a correction and have been submitted, Your Lordship. Otherwise, I have already served a copy, Your Lordship. There was some clerical error on the cost title. That's why.
Understood. You have filed the AIA, but there also, why it is not on record? It has been submitted by Ms. Livika, the learned counsel, appearing on behalf of the respondent number 2 and 3, that an affidavit in opposition has been filed by the respondent number 2 and 3. However, the said affidavit in opposition is not on record. The learned counsel, appearing on behalf of the petitioner, submits that they would like to file a reply to the affidavit in opposition filed by the respondent number 1 as well as the affidavit in.
No, 3.
You only want to file against respondent number 3.
Yes.
Would like to file an affidavit in opposition and reply to the affidavit in opposition filed by respondent number 2 and 3.
No, only 3.
2 has filed or not?
2 has not filed.
So
Your Lordship, here, number 3 is the main respondent, Your Lordship, who has to answer you.
filed by respondent number 3 will go there. Submits that he would like to file a reply to the same. Considering the above, list this matter again on 16th of July 2026. In the meantime, the affidavit in reply be filed on behalf of the petitioners. The registry shall also bring on record the affidavit filed by the respondent number 3 on records.
Right.
16 July.
Much obliged.
Tape level. July কৈছে না? এটা লিখে কোনে? 16 July না? Livil. 16 July. Yeah. Good luck.
Hearing none.